All right, ladies and gentlemen, we're going to get started. All right, please settle down. All right, thank you. Thank you all for being here. We're going to have a busy time, and so before we get started, I want to call on Representative Reeves if you would lead us in a word of prayer.
Let us pray. God of Abraham, in this room where in the early days of the Capitol, legend has it, they kept the horses. Help us to be workhorses today on behalf of our constituents, not show horses. We thank you for your blessings, and we pray for your wisdom and guidance over these proceedings today. Amen.
Amen. All right, thank you.
Mr. Chairman, can I ask you a question before we get started?
Yes, sir.
Are we going to be voting on these bills today or just having hearing? Because, you know, as I mentioned earlier, some of us have 3 and 4 committees we're serving on, so
Right.
we're trying to do what we need to do. So are we voting today or are we just listening today?
We're going to take up the Daugherty County Judicial Circuit bill first,
Okay,
and we will vote on that.
okay,
And depending on how our time runs on House Bill 30, we have a number of speakers. If we can get through that, I anticipate having a vote on it today.
okay, thank you.
All right. So, gentlemen, Judge Lockett, how are you? Good to have you here.
Good to be here.
And we have Judge Chan Caudell here with us. Are you the judge of the week?
Yes, sir, Mr. Chairman.
All right, glad to have you here. All right. So I'm going to call first House Bill 77, and who's taking the lead on this? All right, you got a microphone over there?
I will have one in just a moment. I'm going to switch places with you for the moment.
All right, this, for the listening audience out there, this is House Bill 77. This bill adds a judge to the Daugherty Judicial Circuit. There is funding for it in the budget, and that's about all I need to say about it right now. So I'll turn it over to you, Representative Green.
Thank you, Judge and Mr. Chairman and members of the Judiciary. This is indeed the bill that we have come up with for adding a 4th judge to the Daugherty Judicial Circuit. And I have brought all of these people in here. You can see they're lined up for this particular bill. This bill provides for a 4th judge, as I said, of the Superior Court of the Daugherty Judicial Circuit. And the delegation is asking for the additional judge, and I have here Representative Mike Chokas, and I couldn't, and Representative Bill Yerda, and I think Representative David Sampson is out and couldn't get in. And also my senator has come in support of this, and then Judge Lockett is here for the to speak just a moment if you so want him to speak. But we are all here. This was one of the recommendations of the Judicial Council that we were number 1 on the list, and we're here presenting that today. There is a need, and we have the support of the county commissioners back home, the law enforcement people. They're all been waiting anxiously for this bill to be introduced, and that's what we're doing today. And I would like for you to, if possible, to hear from Judge Lockett just for a moment.
Sure, that'd be fine.
Tag out.
Thank you for the opportunity to be here today, and thank you, our delegation, for introducing the bill. I'm going to try to do something I've been trying to get lawyers to do for 31 years since I've been on the bench, and that is to be brief and be precise. The Daugherty Judicial Circuit is a 1-county circuit in southwest Georgia with about 90,000 people. We have 3 judges at this time. The reason we're asking for an additional judgeship is very simple. We have over 10,000 pending felony cases. 2,500 of those are serious violent felonies: murder, armed robbery, aggravated sexual battery, aggravated child molestation, kidnapping. There are a lot of other cases that are not classified as serious violent felonies but involve gun violence. The only thing that distinguishes them from the serious ones is that they either miss shooting the person or the person survived. 83% of our current jail population of almost 800 involve pretrial detainees. There's almost 200 people in pretrial detention that have been there for 2 years waiting for trials. We have a situation that's bordering on crisis, and we need to have an additional Superior Court judgeship and the additional staff so that we can address these problems and also deal with the civil cases that are part of our jurisdiction as well. As you know, there are certain cases that fall within our exclusive jurisdiction and other courts cannot handle those. In addition to our regular caseload, we have a mental health court, we have a substance abuse court, we have a parental accountability court, we have an alternative dispute resolution program, we have a self-help center that's grant funded to help people with civil problems who cannot afford to hire attorneys, and we have a fully operational county law library. I don't know what it takes to convince you that we need an additional Superior Court judge, but I think the case is made by the statistics. The Judicial Council JWAC Committee, Judicial Workload Assessment Committee, evaluated all the numbers across the state and ranked Dougherty County as number one. The threshold for qualifying for an additional Superior Court judge is 1.2. We're 1.8, highest in the state, and desperately in need of an additional judgeship. Yesterday, our district attorney gave his New Year's resolution to try 51 murder cases in 2023, and those 51 cases involve 140 defendants because most of them are multiple defendant cases involving anywhere from 5 to 14 individuals. I'll be glad to answer any questions if anyone has any about why we're here and why we're asking for this additional judgeship.
Sure. Judge Lockett, I think that you've laid out a good case for what y'all are doing to handle that load of cases down there. So I appreciate that. And for everybody's information, Court of Appeals Judge Ken Hodges, who's very familiar with the Daugherty Circuit, also is in support of y'all getting a fourth judge.
Yes, sir. Just from a historical standpoint, the last time a judgeship was awarded to our circuit was almost 28 years ago, and that's when Judge Herbert Phipps was appointed by Honorable Zell Miller, who was governor at the time. So we have a tradition that also we're very proud of. Thank you.
It's been a long time.
Yes.
All right. Who we got on 12 over here? Representative Kelly.
Just want to make a motion to appropriate time, Mr. Chairman.
All right. Does anybody else have any questions for either Representative Green or Judge Lockett? Okay. Yes, sir.
I do. Thank you, Mr. Chairman. I'm definitely supportive, but you said 10,000 backlog of criminal cases. What's the backlog of civil cases?
The civil cases, the backlog there is relatively small compared to the criminal caseload. The Superior Courts in Dougherty County handle primarily criminal cases. We do have a thriving state court that handles all of those things that are not within the exclusive jurisdiction of Superior Court. So we're not as hard pressed in the civil area as we are in the criminal area.
Okay, that's encouraging. And do you estimate that if this is approved, that you'll be able to clear the backlog within a year, 2 years? What's the sort of time frame to get caught up?
It's hard to predict because, of course, there's no stop in the cases coming in.
Right.
You know, the chute is still full and the numbers keep increasing. But we do feel that within a reasonable period of time, maybe a couple of years, we'll be on an even keel. But right now we've got a backlog. But the numbers are high, not just because of the pandemic and the slowdown during the pandemic. They're just growing by leaps and bounds based upon the conduct in the community.
Okay, thanks.
All right. Representative Reeves?
Thank you. You know, they say all you need to know you learn in kindergarten. I went to kindergarten in Albany, Georgia. I'm proud to represent Gwinnett County now, but what I remember about Albany from growing up and then throughout my lifetime is it's a regional town. So for my friends in Metro Atlanta or a circuit that has more counties, remember Albany has folks coming from Americus like Representative Chokas represents, and and other small towns. Large hospital, Phoebe Putney's there. So folks are coming to get medical treatment, and then you got a lot more real estate, commercial real estate and traffic, and you've got a little bit more anonymity and crime to bear for the region in Southwest Georgia. So thanks for the work you've done. Something that came up at the last meeting, I've talked to Tracy Mason from Judicial Council about this. Y'all have gathered a letter of support from the county for this, and the county's committed to doing the supplement and office and everything like that at the local level.
Absolutely. Chairman Chris Cahilas and the entire commission fully endorsed our request, and they're prepared to write a check.
Most
I know
important.
that's the bottom line.
Okay. All right, I do want to point out to the committee that the original bill, we now have a substitute, LC 491198S. The original bill had the timing of the appointment as of, would be January 1, 2024, and that would put the election of the new judge that May. So to give that judge more time to establish the incumbency, we moved it to July 1st, 2023. That's what the sub does, basically. All right. And let's see. Any other questions? All right, this time I'll recognize Representative Kelly.
Thank you, Mr. Chairman. I move to pass on the committee substitute to House Bill 77, LC 491198S.
Thank you. I have a motion and a second. Any further discussion? All those in favor of the bill say aye. Aye. All those opposed? Thank you. The bill passes.
Thank you. We brought you a good bill, and you made it better.
Thank you so much.
We appreciate it. Thank you.
Thank y'all so much. Judge, can you get up?
Who's-
All right. Clicking them off.
Hey, Sue. Good, good. So, what I'm here for. I sent you some pictures. One, the first
Let it clear out.
I gotta take a look at one. I took one to sand.
We're going to move to House Bill 30. We've got a number of speakers to the bill, and we don't have that much time. So what I want to do is I want to limit the amount of time that each speaker has to 3 minutes, and then I'll open it up for questioning by the committee, and depending on how many questions they ask, that'll be how long you're up here speaking. So I hope that gives you enough time to make the point you want to make while you're here. And I'm just going to exercise my discretion to jump around in the listing. I may not go down the order of the bill, order of the speakers that's listed here, but I just want to let everybody know that I'm going to try to get to everybody and also give us time to have discussion and vote on the bill. So with that, Chairman Carson, please have a seat. And you have Representative Panich with you also. I know she's a co-signer on the bill, I believe.
Yes, sir, she is. Which one am I talking into?
Let's see, either. I
This
think.
one, okay.
Yeah, they're both. Yeah, that
We
one's
ready?
on. Ready.
Well, thank you, Mr. Chairman, members of the committee. This is HB 30. This provides for a definition of anti-Semitism as adopted from the IHRA, the International Holocaust Remembrance Alliance. This committee graciously passed this bill as House Bill 1274 in 2022. We did make one slight change, and Mr. Chairman, just for clarity, I'm working on LC 491082. Is that what the committee has?
Yes.
What the most of you may remember this from 2022. The only change that we are making is in the bill on lines 43 and 44. This actually came up during House debate, and we just wanted to include this wording just to be very clear that the definition of anti-Semitism includes the examples of anti-Semitism. So you can see on line 43, comma, and includes the examples of anti-Semitism set forth therein. I'm proud to carry this legislation. Again, this definition has been adopted by even more organizations and states since last year. It's adopted by over 1,100 separate governments. It's been passed as legislation in 3 states, Arizona, Iowa, and Tennessee, and then earlier versions were done in Florida and South Carolina, and it's been adopted by executive proclamation or similar to what we would do as far as like a House resolution or what have you in about 20 different states. There's been, I'm sure, like your email's been loaded up like mine in regard to this issue, both in favor and in opposition. But I want to point to you an item, lines 51 through 54. And this bill all it does is creates an objective, internationally recognized standard for what is and what is not anti-Semitism. And lines 51 through 54 clearly state that nothing in this code section shall be deemed to be in conflict with the First Amendment. So this has nothing to do with speech. That has nothing to do with, you can say the worst things about the Jewish people, the Israeli government, their actions and so forth. This is about setting a specific amount of criteria in regard to what is and is not a crime against the Jewish people. And the reason we need this, I hope everybody has in their folders a little summary of the bill. The reason this is needed is because the Jewish identity is really complex and multifaceted. So unlike other crimes, the crimes against the Jewish people could be very multifaceted, could relate to religion, race, national origin, ethnicity, and so forth. And what this does is, for the first time, creates a definition in our Georgia code that's internationally recognized that prosecutors can use when prosecuting crimes perpetrated specifically against the Jewish people. With that, Mr. Chairman, I'm happy to turn over time to a couple of speakers. Mark Goldfeder is a very well-known speaker about this, but I guess we're saving questions for the end. Is that
No, but before we jump to the other speakers, I'll ask if anybody has any questions. And
okay? Very good, very good.
All right, go ahead.
Thank you, Mr. Chairman. Chairman Carson, thank you for bringing the bill. I was trying to remember last year, didn't we have a pretty lengthy discussion about the definition of it itself that you're referring to, and
That's right.
lines 42 through 44, and there's 2 situations there that I want to ask you about. For clarity within the code, as far as, prosecuting this, I know you refer to that, but would you not be open to actually putting the definition itself within your bill?
I would I ask for the indulgence of the committee, but my preference and the preference of these various groups, most, if not all the groups that you see on the bottom of this page, Chairman Smith, is to refer to the definition. And we've had this question come up a couple of times, and I fully understand that. I'm not an attorney. I can't speak to that level of detail. But what I will say is that if you would take those words from the International Holocaust Remembrance Alliance, and I have the printout actually from last year, and this was a definition of anti-Semitism as adopted by the IHRA in May of 2016. To answer your question, if you take their wording, if you take their verbiage and you put it into OCGA, then at least then into a bill, then it becomes subject potentially, very potentially subject to, well, let's tweak this for Georgia's application. Let's tweak this word over here and what have you. And so what we want to do is preserve the integrity of a definition that is internationally recognized and leaned upon by numerous states, numerous federal agencies, and numerous governments around the world. I understand your question, but the reason being is because it invites people to potentially edit, tweak, what have you, and that's the last thing I want to do is vary from the definition that's been internationally recognized and adopted.
Okay.
Thank you for your question. That has come up from several of you. It's a very valid question, but that is the reason.
All right, Representative Silcox.
Thank you, Mr. Chairman. I was just going to add that I think that it's important to define this because of our hate crimes legislation that we passed several years ago, or if prosecutors are going to add that charge in a case, they need a definition to work off of.
Okay.
Mr. Chairman, would you like me to read the definition? Brock, is this in the, okay, I'm sorry.
Okay. Who's got number 3 over there? All right. Representative Hong, is that you?
Yes.
Okay.
Yes. Does this work? Oh. Thank you, Mr. Chairman. On the same note as what our concerns are, it does say it's a working definition that was adopted on May 26, 2016. What happens if there is an incident where they tweak a word or tweak the definition in the future?
Then we still go back to this definition as of May 26 of 2016.
So
that's a very valid question, but what I would say is the Georgia Code would rely upon this definition as of this date in the wording therein, and not subsequent edits unless this committee adopts those edits. That's not what we're asking for at this time.
Thank you.
Okay. Over here was. Who's got 16? Is that Representative Leverett? Next 16, next one up. No, not the other way. There you go. No?
Is this it?
There you
there
go.
we go. Thank you, Mr. Chairman. Thank you, Chairman Carson. In the definition that's online, it does talk about rhetorical manifestations of anti-Semitism, does it not?
Rhetorical and physical manifestations of anti-Semitism are directed toward Jewish or non-Jewish individuals in their property, yes, and it continues.
All right. Now, isn't a rhetorical manifestation speech? I thought you had indicated it was not intended to inhibit speech.
I would lean on other scholars in regard to that, but I would think the actions that are carried out, I hear your point, but this only applies to actual crime rather than anything protected by the First Amendment.
I guess my concern is I'm not sure the definition is that narrow.
I understand.
I mean, you do have the exemption in here to saying nothing shall be construed to diminish or infringe upon any right protected on the First Amendment, which
yes.
is generally speech.
Yes.
But the definition itself seems to me to include speech. And frankly, there's some anti-Semitic speech, if it ain't legal, it ought to be. So that's just a concern I have with the definition itself. That's one. The other one is it says it's a non-legally binding working definition on the website, which makes me feel like we need to take this definition and make it a legally binding one rather than just refer to it.
I understand. The plenary in Bucharest, where this was adopted, yes, they said adopt the following non-legally binding working definition. I think that it's from my standpoint, that was adopted with that wording non-legally binding because it was a non-governmental entity embracing that definition.
I see. So it's because the entity promulgating the definition itself didn't have any effective law.
Correct.
Okay,
Whereas state of Georgia does, whereas
Yes.
state of Kentucky does, whereas state of Florida does, yes.
Well, one other question, Mr. Chairman.
Yes, sir.
Do you know if the other states that have adopted this definition did so by just a reference to it rather than copying and placing in the code book?
I would defer to others about that, but I believe almost all, if not all, have done so via reference.
Just by a reference to it.
Correct.
Okay. All right.
Because they had the same concern. And it's a very valid concern. Those same entities, various states, agencies, and so forth, they have the same concern that, frankly, I do with regard to inviting editing of an international recognized definition. But I take your point.
Representative Holmes.
Thank you, Mr. Chairman. I have the same concerns that have been expressed in terms of, one, working definition connotes something that isn't final. And what I heard from you is that it can be viewed as final and that the expectation would be that it would be on the website with a reference to this date, and then anything that revises the working definition would be updated with a new date. Is that fair or not fair to say?
Yes, that is correct. So what we're doing on line 43, beginning on line 42, working definition of anti-Semitism adopted by the International Holocaust Remembrance Alliance, IRA, on May 26, 2016. So yes, it is called a working definition, but we're referring to that definition as of that particular date.
Okay.
Yes, thank you for that.
And I think the concern that I have is if the examples change or if anything on that page changes to reflect the definition that's not consistent with what it is now, then that would be an issue. And then the second thing is with respect to the definition itself, it does seem like it would need to be defined. And I'd like to pose a query as to whether or not in Georgia code, other than maybe a reference to the United States code, if we have anything that even looks like this.
I'm not aware of it.
Me neither. So,
I would again defer to some legal scholars after me to speak to that.
okay.
But to your in regard to your second question, in regard to your first question that you had in follow up, again, anything that would be adopted after and not part of the May 26, 2016 definition would not be reflected in Georgia code because we're referring to this as of this date. So to your point, if there was some changes, an additional example was added, for example,
Yes.
after a particular hate crime, that would not be reflected in the Georgia code because we're referring to this definition as of a certain date.
Right,
And
I understand that, but what I'm asking is, I think the only place to get this is online, right? So if it's online, if it's not completely separated and identified as what was existing as of this date, frozen in time, without being updated, and then if the new links represent whatever the changes are, if that's to happen, it may not happen. The working definition may stay the way that it is for
I believe
time,
it says the way it is.
eternity.
But
You know what I mean?
I understand.
But if we're going to refer somebody to a place for a definition, we have to make sure that that definition does not change and
That's
is always
correct.
the same.
That's correct. And I think some constitutional scholars can speak to this after me
Okay. Thank you.
to answer you address your concern, right?
All right. Chairman Smith.
Thank you, Mr. Chairman. Chairman Carson, just for argument's sake, I mean, it seems like we're kind of trying to hone in on whether this part of line 42 working definition, I mean, if it would please the author of the bill, I mean, I think that would kind of help alleviate a little consternation because, I mean, the plain reading of the statute, I mean, I'll defer to the chairman of this committee as a judge in interpreting this. I mean, you reference May 26, 2016, it says working definition. I mean, that's something, although we may sit here and hash this out and understand it ourselves, what about judges 15 years from now, 20 years from now? That's more of what I'm concerned about. And so, I mean, just throwing that out there, I know we're not in the posture for that just yet, but does that destroy the intent or the aim of your bill if we were to just strike the word working?
Well, I would go back to, again, what it is being referred to by International Holocaust Remembrance Alliance as a working definition in their literature. So I don't know if that helps or hurts the integrity of the bill or those judges and decisions in court cases you're talking about from 10 and 15 years from now. I can't speak to that. What I can't speak to is it's being referred to as a working definition by IRA itself, all the way back to 2016.
Okay.
And that's the only reason it was listed as a working definition.
Vice Chair Reeves.
Mr. Chairman, I know members of the committee have the definition, and Chairman Carson has referred us to the internet and given resources, but just because we have so many people present and online, for the benefit of this deliberation, I want to read it. The term anti-Semitism shall mean and refer to rhetorical and physical manifestations that, taken into account the overall context of hatred or violence toward the Jewish people or non-Jewish individuals and or their property, toward Jewish community institutions or Jewish religious facilities based solely on their ethnicity or religious or cultural membership or association with Jewish people or institutions. And then there are 9 or more examples of the manifestations, actually 11. But what I wanted to point out, I don't believe that's merely rhetorical. I think it does cross the line into physical manifestations and hatred and violence. And so I don't want people who are listening who don't have it in front of them to read themselves to come away with the impression that we're talking about mere words. We're talking about physical manifestations in addition to rhetoric. We're talking about hatred and violence and inciting violence. And discrimination is in this definition or the statutory proposed language. So it's not mere rhetoric, in my opinion. I'll let everybody on the committee look at it, and I'd be glad to hear from members who are here to speak on the bill, but it's not mere rhetoric. Anti-Semitism in this definition is not mere rhetoric.
Thank you for that.
Representative Kelly.
Thank you, Mr. Chairman. And Chairman Carson, maybe this is a question for the some of the experts you brought with you, but I'm just trying to get a understanding of how many states you said have adopted this. 5?
I can read them off: Arizona, Iowa, and Tennessee.
Okay.
Through legislation. I just want to be very clear. Not all these states have adopted via legislation. Via legislation, it's Arizona, Iowa, and Tennessee. And then via executive order, New Mexico. Other versions of the bill, not exactly like this, but other versions were adopted by Florida and South Carolina. And then there's another 22 states that have adopted this similarly to the way we would a House resolution or something like that.
And if I continue, Mr. Chairman,
You may.
because I'm supportive of the concept. I think we have seen a rise in anti-Semitism. We've seen increased violence on the Jewish people, both at home and abroad. Unfortunately, we saw something over the last week.
Right.
Senseless tragedy. I'm trying to just wrap my head around in practice. When we did our hate crime legislation, there are times when speech does rise to the level of criminal activity, right? Yelling fire in a movie theater,
Right.
For example. Inciting a riot, other things, where if you refer to people in certain terms and then you commit the physical act upon them, that's kind of how we allow people to be prosecuted under our hate crimes legislation. I guess I'm trying to just understand in other states that have adopted this, how the prosecutions have gone in these other states. And maybe that's a question for Mr. Feldman.
Probably Mr. Goldfeder.
Go Feder, sorry.
Okay.
Because I'm sorry, Mr. Chairman, but to Representative Kelly's point, he's asking about how is this definition used in case law, I think is overall the question.
I know people say a lot of hateful things about the Jewish people.
Right.
And so I'm trying to differentiate someone who may post or rant on Twitter, which would still be, while maybe not legally, not illegal in our country, would certainly be immoral in our country. How does that then, if they don't act on it, I guess I'm just trying to see if someone goes on Twitter and says something hateful about the Jewish people, and then a week later there's a shooting in that community that person lives,
Mm-hmm.
or in that state where that person lives, but that person had no relation outside of just sending a tweet. I guess I'm trying to just see practically how does the speech line up with the required action? That's what I
Understand.
guess I really just want to have a better understanding of.
I understand.
and Representative Leverett.
Is this the right one again? Okay.
Yes, sir.
Thank you, Mr. Chairman. As I interpret the statute, it's in Title 50, which is the state government statute, correct?
Chapter 1, Title 50, yes.
So that is not a criminal statute, correct?
Correct. General government, I believe, is the code
And
title.
so, the one issue that makes me less concerned about some of these issues, although I do still have some of those definitional concerns, is this is really, you're trying to help define and set state policy with respect to what institutions or private actors might be exhibiting discriminatory behavior that would disqualify them from state benefits or state contracts. Is the way I understand this. And just if you'll comment on line 45, it says all state departments and agencies shall consider anti-Semitism as evidence of discriminatory intent for any law or policy in the state which prohibits discrimination based on race, color, et cetera, or provides for enhanced criminal penalties for criminal offenses. So it does reference criminal offenses, but it is not contained in it. We're not really creating a crime per se.
No, we're not creating a crime, and we're not creating a separate class. We're creating a criteria. That's what we're doing.
All right.
Thank you for that question.
To Chairman Kelly, he may, because it does reference criminal offenses, he may still have those same questions and concerns, but I thought it was important to say we're not.
Yes.
And we're not enacting criminal statute here.
Right.
Chairman Smith.
Mr. Chairman, thank you. Chairman Carson, I like this bill. It's just trying to accomplish the goal here. You know, I'm thinking about, let's look at other law in the state. I think about, we just came off of duck season here in the state of Georgia, and that's a federally regulated bird. And that, in essence, is also part of a agreement between the United States, Mexico, and Canada hunting migratory bird, which is species of duck and geese here in the North American hemisphere. So what I would suggest is, as far as, you know, in line 45, you're talking about anti-Semitism being considered by these state departments. Well, I think to have a better legal footing, I'm trending towards wanting to see the actual definition in code. KISS, the acronym, keep it simple, sweetie.
Okay.
That is something that I would prefer. We already have some issues with prosecution in our state as it is in certain areas. I think the more expressive a definition we give, that may be a little bit more comfortable for some of us on the committee. If you'd be open to that, I mean, as far as something binding, because I'm worried about, you know, how would someone's defense lawyer try to challenge this?
I understand.
And trying to make sure that we withhold the scrutiny that we may be placed through. I think that if we place the definition that was adopted on May 26, 2016, that I think would withstand most of your constitutional challenges. Not to mention, there's all sort of 10th Amendment issues for me in this as well. As far as, you know, if this is allowed for the state to pass a statute on, then let's make sure that we make it as close to what the Holocaust Remembrance Alliance has done, but still making sure that it's within Georgia's purview.
I hear you. I believe, yes, we've talked about that. We've answered those questions last year and over the interim. On that, I would talked about some constitutional challenges, maybe not challenges, but issues with some of the speakers to come after me.
Okay, thank you.
But I hear your concern. I would note that we do, particularly in the health code, refer to federal definitions almost all the time, all throughout our code. But I hear your concerns.
All right. I don't have any other questions at this time. Representative Panich, did you, as a co-author or co-signer on it, did you want to say anything?
No,
All right. All right. At this time, I'm going to call Mr. Goldfeder up. Here you are, sir. And John, you can stay. You probably need to stay close.
I probably do. Sorry. Do you want that one? Okay.
All right, sir, if you would introduce yourself, tell us the organization you're with, and then
Sure.
give us your statement.
Good afternoon, Mr. Chairman, honorable members of the committee. My name is Mark Goldfeder. I'm director of the National Jewish Advocacy Center, special counsel for the American Center for Law and Justice, and I'm general counsel for all of the Hillels and all of the campuses here in Georgia. I'm a former law professor. I've taught the First Amendment at both Emory Law School and Georgia State College of Law. I also wrote the law review article that outlined the model bill that HB 30 is based on. There's been a lot of misinformation about this bill. I wanted to start by clarifying what the bill does not do. The bill does not criminalize anything. It does not criminalize hate speech about Jews or about Israel. It does not criminalize criticism of Jews or criticism of Israel. It does not limit or chill criticism of Israel or of Jews. It does not have anything to do with protected free speech. The IHRA definition makes clear that some speech is anti-Semitic, but the bill does not use the IHRA definition at all when it comes to speech. And this isn't a he said, she said debate about what the bill does and doesn't include. All of you have the bill in front of you, and you can see that I'm telling the truth. Take a look at lines 45 to 50. It has nothing to do with speech. It only addresses discriminatory acts and hate crimes committed against Jewish people. Unlawful discriminatory conduct can range from illegal hiring, firing, or housing decisions to hate crimes and discriminatory harassment. None of that is protected under the First Amendment. By the way, the bill doesn't even criminalize hate crimes against Jews. Those are already illegal. All the bill does is ensure that when you are analyzing the intent behind illegal discriminatory actions, when there is an allegation that the person chose their target because they are Jewish, that authorities should consider the world's most well-accepted definition of anti-Semitism. And there is no debate that this is the world's most well-accepted definition of anti-Semitism. Presidents of both parties, our federal government, over 1,100 entities, the UN Secretary General, everyone has agreed. Of course, you will find people on the fringes, even within the Jewish community, because we are not monolithic, who do not support the IHRA definition. But the vast majority of Jews across the entire world and across every spectrum do embrace it. And there are leaders of the Georgia Jewish community here today representing tens of thousands of your constituents who do support it. So the bill has nothing to do with speech, but again, in case you weren't absolutely sure, there is that savings clause in lines 51 to 54, which clarifies the bill cannot infringe on any First Amendment rights. So let me be just absolutely perfectly clear to head off any debate. A person can stand up and say anything they want about Jewish people or about the Jewish state. Online, in person, the bill does not in any way affect their ability to do so. Now, if that person were then to commit a hate crime against a Jewish person, and there's an allegation that they selected or targeted their victim because they are Jewish, then the relevant authority should use the anti-Semitic statements they made as evidence of the intent behind their act. A unanimous Supreme Court, United States Supreme Court, in Wisconsin versus Mitchell, 1993, held that when it comes to evaluating discriminatory actions, and I quote, the First Amendment does not prohibit the evidentiary use of speech to prove motive or intent. That is how all anti-discrimination laws always work. And the court also said that doing this does not chill free speech. So unless anyone is planning on committing discriminatory acts or hate crimes against Jewish people, this bill should not concern them. Now, if it's so narrow, why is the bill necessary? Because despite the rise of anti-Semitic incidents around the country, and yes, around Georgia, recent studies have found that nearly half of all adult Americans say they do not know what anti-Semitism means. All this bill does is plug that hole in anti-discrimination law. It does not create a new protected class. It is not about Jewish exceptionalism at all. It's about ensuring Jewish equality. What does it look like when there is no definition? Samantha Streltzer was a student president of her school here in Georgia. Some of her classmates decided that as a Jew, she was too closely affiliated with Israel, and they began to harass her till she no longer felt physically safe at school. The school in question wrung its hands for months, saying, they don't know, is this anti-Semitism, it's just political? Well, the IHRA definition answers that question, holding American Jews collectively responsible for actions of the Jewish state and then discriminating against them is anti-Semitic. It's not always about Israel. There have been dozens of swastikas and threats, and you'll hear more about that from others. Some of the students who have been affected are here. And the schools just shrugged their shoulders and said they just don't know. If you think it couldn't happen here, it does happen here. So please don't be confused. The bill is not about protecting Israel, it's about protecting Jews. Many times, Jews are targeted because of a real or perceived connection to Israel. You can say whatever you want about Jews or Israel, you just can't attack Jews because you hate them. So to sum up, you cannot fight something that you cannot clearly define. The IHRA definition is excellent, nearly universally accepted. The definition itself literally says that criticism of Israel, like any other country, is not anti-Semitism. But regardless, this bill in front of you has nothing to do with speech. Now, I know the opposition sent a letter with a bunch of stories about how IHRA could have been or would have been misused in other contexts, like campus speech codes. First of all, those stories are not accurate. Many had nothing to do with IHRA. Second, I fully agree. IHRA should never be used as a speech code. But none of those stories had anything to do with this bill or any of the bills like it. This bill is not a speech code. Versions of this bill have passed in several other states. There's not even a single allegation that this bill was ever used in any form to silence speech because it can't be as written. The bill in front of you, HB 30, is a constitutionally sound way to protect Jewish people who clearly need protection from illegal discrimination and harassment. It has nothing to do with protected speech, and I respectfully ask that you please vote in favor.
All right, anybody have any questions? I have one. The definition and the use of a hate crime statute. I guess what I'm hearing from y'all is that this would not become an element of a crime that a prosecutor would have to prove in court. Is that what you're saying?
It is already illegal to discriminate against someone on the basis of race, religion, ethnicity, national origin. The problem is that anti-Semites say, well, it wasn't based on this or that characteristic of a Jew, so it wasn't anti-Semitism. And prosecutors sometimes throw up their hands and say, well, we don't know what to do. What this says, it tells prosecutors, listen, if they targeted a Jewish person and they've made anti-Semitic statements in the past, that might be evidence of why they targeted that person. But it doesn't create any new protected class or any new crime.
Okay, thank you. Who was it?
Yeah. Needless to say, as an African American, we've gone through all kinds of hate crimes too. And I guess what I'm trying to figure out is what this does for Jewish people that is not already covered in code and other codes. Because as I sit here and I'm listening to you, I'm trying to figure out if we need to be doing something as African Americans to do the same thing that you're trying to do here. I'm just not sure I'm seeing the difference between what you're doing here and what's already covered in code.
Thank you for that question. First of all, there are other communities who have similar problems. I've been working for 2 years with the Hindu American community. They've created their own definition based on the IHRA definition that they're trying to do the same thing. But if there is any community where they're being targeted and people are claiming that it's not based on a protected characteristic, they absolutely should organize and do the exact same thing. So the question is not about what other communities should do. Everyone should do what they need to do. But do the Jewish people need this? And demonstrably the answer is yes, because time and time again, we see Jewish people, particularly students, who are targeted for their Judaism. And then they're told, well, we don't think it was anti-Semitism. Again, do you want to read the statement? If you'll indulge me, I'm going to read you a statement. We have a student here who suffered. He's here with his mother and his brother. And I'm going to, he shared with me this statement, and I will, if it's okay with you, read it into the record. This is a letter from Aaron, an 18-year-old student. My name is Aaron, and I'm having my statement read as this experience is still very painful to discuss. In fact, it's the lowest point in my life. For over 18 months, my brother and I were terrorized with anti-Semitic symbols, finding swastikas on the bathroom walls, graffiti stating kill the Jews, gas the Jews, swastikas saying Nazi, Hitler salutes in class, as well as students surrounding us, throwing money at us, and screaming anti-Semitic slurs. It's an experience that still affects me to this day. I believe this would not have happened if there was a definition of anti-Semitism. I was told by numerous school staff, including teachers, social workers, administrators, that what I was witnessing was not anti-Semitism. It wasn't a swastika, but a peace symbol, and that the other graffiti scribbled on the walls was not anti-Semitism. The swastikas appeared almost daily, and things got so bad that I contemplated suicide. I was 13 years old at the time. I've been in therapy ever since. I truly believe this did not have to happen. Had there been a definition of anti-Semitism, there would not have been a question as to whether the swastikas aimed at me were anti-Semitic. Would have been over before it started. Definition would not allow it in action. The reason I'm here today, as painful as this is because I do not want this to happen to another kid. Not all kids have a great mom who recognized the sins of suicide. I often wonder how many kids were lost because they did not have one who knew what to look for. The terror I experienced in school takes place outside of the school system in society, as can be seen by the high rates of hate crimes. That is why the definition of anti-Semitism is imperative. I want to just acknowledge Aaron and his family who are sitting in the back, and I will also tell you that just this week alone, in Fulton County, hundreds of parents signed a change.org petition asking Fulton County to please finally take seriously the allegations of anti-Semitism happening in their schools because their children no longer feel physically safe. So the answer is, it is already illegal, it should be covered, but it's not, because people drive a bus through that hole of what does anti-Semitism mean, and they're able to hide behind it. Now, the federal government recognized this problem to its credit a long time ago. In 2004 already, they realized that most of the time, Jews are not discriminated against because they do or do not keep Shabbat or do or do not light candles on Friday night. It's because of their race, ethnicity, or culture. But they weren't protected under Title IV because Title IV doesn't protect religion. So the federal government moved and said, you know what, Jews are multifaceted, they're protected. In fact, they use the IRA definition now when it talks about anti-Semitism. But states have been slower to catch up. And all this does is plug that hole as a practical matter to help students and others like Aaron who really need that definition.
By reference.
By reference.
They use the definition.
They use, right, the State Department, the Department of Education, and the Department of Justice all use it by reference. The AJC says that it's called a working definition. They wrote the definition because it's meant to be put to work. It's meant to be put practically. But as I'm sure many of you know, in order to incorporate a statute by reference in legislation, it required to be static. Otherwise, it would be an unlawful delegation of authority to an outside body. But if you reference it by static definition to a date, courts have across the board held that that's an absolutely legal way to reference by incorporation within a statute. Oh, I'm sorry. The American Jewish Committee is the one who wrote the
Not the other AJC. No.
Sorry.
Just for clarity.
Vice Chair Reeves.
I want to respect, since we have juveniles, privacy, but just general area, what county or what area you mentioned Fulton, so that would be North Fulton or South Fulton. City of Atlanta has their own system. So the incidents you mentioned two, I think, one with the letter you read, and then you mentioned a previous one about a valedictorian getting bullied. Where?
student president, that was at Emory University.
Okay, so that was college.
And the student North Fulton.
North Fulton. Okay. And let me just say, for the school systems, when I was going through school, K through 12 and college, this kind of stuff would not have been tolerated. So I don't know what's going on, but school systems, I think, should take a little bit of an active role. That's part of education, not to have bullying like that going on.
Okay, Representative Panich, if you want to swing that around.
I just want to say it's happened to my own daughter at UGA. She had swastikas on her door when she was pledging a Jewish sorority, and it was obvious, and it was on her door. So these acts still occur, even here, and they're increasing.
Okay, thank you. Any other questions? All right, sir, thank you.
Thank you for your time.
Just gonna run down. All right, Rabbi Peter Berg? No? Not here? Okay. Julie Katz?
Chairman, did you want me to stay up here, or whatever the committee's indulgence of, that's what I'll do.
It would be handy if you can stay. I understand
Okay.
you have another committee as well.
I wasn't looking to leave for that. I just didn't know if you wanted me to sit here during the question. That's fine.
Yeah. All right. Ms. Katz, if you would introduce yourself and the organization you represent.
Sure. My name is Julie Katz, and I'm the Associate Director of American Jewish Committee's Southeastern Office.
All right.
So I'm here today as a representative of AJC, which is a global Jewish advocacy organization. And anti-Semitism is one of our primary issues. So you actually just heard a statistic referenced about a survey that we did called the State of Anti-Semitism Report. And I'm going to share about that report, but first I want to share an example that happened just last year about why it is so important for us to define anti-Semitism. 1 year ago, a gunman walked into a synagogue in Colleyville, Texas, and held 4 Jews hostage. His motive? There was a convicted terrorist being held in a prison near the synagogue, and he thought that Jews controlled the media, Jews controlled the government, and Jews had an inordinate amount of power. And if he held these Jews hostage in the synagogue, then he could accomplish his goal of getting this terrorist released from prison. Most people in this room would recognize that as an age-old anti-Semitic trope. But, as referenced earlier, 50% of Americans either have never heard the term anti-Semitism or don't know what it means. So when anti-Semitism is coded and multifaceted and based on conspiracy theories, like the one that this gunman believed, it's very easy to see why it's so important to have a definition. The FBI, when they released a statement about what was going on in the synagogue, they said that the gunman was not motivated by anti-Semitism. Let that sink in. Arguably one of the most important and most influential law enforcement agencies in the country did not understand one of the age-old anti-Semitic tropes, the biggest one of the biggest. So I tell you that story because we've shared about personal stories and we've shared about harassment of young people, but I want to share with you why this becomes something where people can literally get killed. I'll finish with a few statistics. In AJC's State of Anti-Semitism report, we have found that 9 out of 10 American Jews are concerned about anti-Semitism. 25% of Jews in America will hide physical symbols of their Judaism, their skull caps, their Star of Davids, the mezuzah, one of the most important symbols on their door, out of fear for their physical safety. And when you consider young people under the age of 30, young people my age, that number rises to 40%. So I share these stories with you, I share these statistics to ask you to please adopt the working definition of anti-Semitism, to please help the Jewish community stay safe and be free from fear, discrimination, and violence. Thank you.
Okay. Thank you, Ms. Katz. Hold on before you go. Any questions for Ms. Katz by the committee? Thank you, ma'am. David Small. Okay. Well, I think what I was going to do, you can time it too. All right. So that we help everybody, I'm going to start a clock and set it out there so you can see what it's doing.
Sure, I'm short. Not
Okay,
much.
hang on. All right. Take off.
Excellent. Hello, I'm David Small, a retired archaeologist and a member and assistant clerk of the Atlanta Friends Meeting, also known as Quakers. Quakers believe in the inherent worth and dignity of every individual, and this extends to all people regardless of race, religion, or national origin. We believe that that of God, the spark of the divine, is in every person, and that all people should be free to express their opinions, even if those opinions are critical of the actions of governments and nations. This belief in free speech is a fundamental aspect of our faith, and it is what sets us apart from those who would silence dissent and suppress the voices of those who hold different views. Thus, I'm here to stand with my Jewish and Muslim brothers and sisters in opposition to House Bill 30, which seeks to redefine anti-Semitism in ways that violate the First Amendment right to free speech and directly undermines legitimate critique of the state of Israel's actions and policies.
The U.S. Supreme Court has repeatedly emphasized the importance of free speech in a democratic society and has only allowed for limited restrictions on speech in specific circumstances where it would cause imminent harm. The protection of speech, even if controversial or unpopular, is seen as crucial for the exchange of ideas and maintenance of a vibrant democracy. Bills such as HB 30 are unwarranted and are being used to undermine civil liberties while failing to address real bigotry. This is part of a larger effort to legislatively challenge traditional definitions of anti-Semitism by terming all criticism of Israel and political Zionism as forms of anti-Semitism. At a time when real anti-Semitism is on the rise, this is particularly dangerous. Rather than focusing on silencing debate, we need to be looking at the political environment that is enabling violent anti-Semitism, Islamophobia, and white supremacy on display in places like Charlottesville, Pittsburgh, Portland, and across the country. We can and must do better, which is why I'm here to stand in opposition to this bill.
All right. Thank you. Any questions from the committee? Representative Leverett.
Thank you, Mr. Chairman. Good afternoon, Mr. Small. Thank you for testifying today. Are you speaking on behalf of the Friends Society or just personally, individually?
I am not. I am speaking as an individual friend, yes.
Okay.
As an individual.
That's what I suspected. I just want to make sure. So I gather, are your concerns primarily related to potential chilling effect you're concerned the definition might have upon criticism of the state of Israel as a country and not as part of some grand, I don't even want to say it, but, you know, vast, worldwide, whatever?
Right. The American Friends Service Committee, the Quakers, are a member of Churches for Middle East Peace. We've been in Israel, Palestine since the early 1800s. Our Friends School is in Ramallah, which has educated political, cultural, business leaders in the Quaker traditions of simplicity, peace, integrity, community, and equality since 1869. We were awarded the Nobel Peace Prize in 1947 for our humanitarian work during the war. And in 1948, we were invited by the UN to administer Gaza, which we did until 1950. So our relationship with the Holy Land goes back for centuries. And we're concerned, along with the Churches for Middle East Peace, and along with all the leaders and patriarchs of all the churches in Jerusalem, that there is legitimate critique of policies and procedures of the state of Israel that will be silenced if these bills go through.
One more question. And I think that's what I sense from some of your testimony. What I'm asking is, if a specific express exception were made in that definition to legitimate criticism of the state of Israel, however we define that, would that alleviate a large degree of your concern about the bill?
I'm just concerned about how the bill would be interpreted as well, because I'm not sure that it will solve the underlying issues of bigotry in this country, and that it's not resolving the problem. It's just confusing it in many ways and shifting the resolution to legal terms rather than public involvement.
Well, I suppose I agree with you, but I would say that we're not necessarily, you know, when we pass a murder statute, we don't eliminate murder. We just provide a means to punish it when it happens. So I think what I'm sensing from your testimony is you believe there are some broader concerns, although a large part of them do have to do with legitimate criticism of the state of Israel, and alleviating that concern would help, although it would not completely rectify your concern about the state.
That's
about
true.
the proposed bill.
That is true.
And thank you so much.
Thank you.
Thank you, Mr.
Representative Kelly.
Thank you, Mr. Chairman. Mr. Small, can you give me any examples in the other states that have adopted this definition where someone was prosecuted solely for criticism without any physical manifestation of violence?
No, I'm sorry. I'm a retired archaeologist, so my background is in Middle East, Near Eastern archaeology, not in the law.
I appreciate that. I just thought maybe since you were testifying before, you may be able to give us that. And I do want to, I'm thinking back to the comments from the minority leader yesterday, and this isn't directed at you, but you made something. You said that this is we're not going to solve bigotry with this piece of legislation. I agree with you. I wish we could. I wish there was a way that we could solve all the moral problems we have in our country through legislation. We can't. We won't ever be able to. And I just remember the minority leader yesterday from the Florida House quoting Dr. Martin Luther King, and he said, just because it's a morality issue doesn't mean you shouldn't try and help put guardrails around it through legislative action. And Dr. King was right then, and I think that same sentiment carries here today. We don't, other people have to deal with the morality issue, but we have to put the legal guidelines around it. But thank you for being here today.
Right, and I should say, because my name is David Small, Klein is German for small. A number of Jews anglicize their name. I've spent the last 30 years working in Israel. People think I'm Jewish all the time. I speak Hebrew. I live there, and so I've experienced what would be anti-Semitism, even though I'm Quaker. And so it is a real problem. It is a terrifying problem. I just don't think this is the right solution to deal with the underlying causes of anti-Semitism.
Okay. Representative Holcomb.
Thank you, Mr. Chairman. I'm trying to understand this, and I don't think that there's an intent by the committee to do anything to suppress or restrict free speech. And what we heard from the prior speakers was that this is only going to be used in two contexts. It's going to be used in the context of a civil suit concerning discrimination, or it will be used in a hate crimes suit where they're trying to identify what was the motive behind those two incidents. Mm-hmm. So with that as context, if I were to criticize, say, for example, the policies of Benjamin Netanyahu, I find it unlikely that a jury would then conclude that that is anti-Semitism. However, if some of the examples that Aaron went through, and I think all of us feel terrible about his experience and the others that we've heard, they might reach a different conclusion. I don't see anything within that that limits free speech with respect to the discussion of policy. Can you correct me if I'm wrong on that?
No, I really don't. No, I can't.
Okay, thank you.
Vice Chair Reeves.
I've heard from Jewish people about the bill. I've heard from Muslims about the bill. I've heard from Christian Arabs about the bill from my district in Gwinnett County. I have not heard from any Quakers, so I'm going to ask some questions because
Sure.
On my previous work on this committee and so far on this legislation, have not heard from Quakers. And to have a Quaker archaeologist, definitely I've got an expert in a couple of fields. So 3 questions. Number one, as a Quaker, do you believe in the free exercise of religion?
Completely.
And as a Quaker, do you believe that it's wrong to engage in violence against someone based on their religion or ethnic background?
Completely. Quakers are well known for our peace testimony and our peace activism in the world.
And as a Quaker, do you believe it's wrong to engage in discrimination in various forms, employment, education, things like that, based on religious or ethnic background?
Completely. It goes against our testimony of equality, where all people are considered. We consider that of God is in every person, no matter what their religion. So, completely against all of that.
And final question: Benjamin Franklin was a Quaker, right? If I remember right.
No, Benjamin Franklin was not.
Okay.
William Penn
who was William Penn? All right. I knew one of the founding fathers. So, hats off all the way back to the founding of the country.
And even then, I should say, when the Quakers came to Pennsylvania, their idea was, let us first try love with the Native Americans, as opposed to the other colonies values which were established.
Philadelphia is the city of brotherly love. All right.
Exactly.
So the principles you've mentioned, I want to make sure they all got publicized to the committee. Thank you.
All right, any other questions? All right, thank you, Mr. Small.
Thank you.
Let's call him. All right, Murtaza Khwaja, hope I got that right. Come on up. I hope I didn't butcher your name too bad.
No, you were very close.
Okay. If you would tell us who you are and who you represent.
Absolutely. Good afternoon, Chairman Gunter, honorable members of the committee. Thank you for the opportunity to speak on HB 30. My name is Murtaza Khwaja. I serve as the Executive Director of CARE Georgia. CARE, for those of you who may not know, is the Council on American Islamic Relations. We are the nation's largest Muslim civil rights group. We promote, advocate for, and defend the civil rights and liberties of American Muslims, and extension, all of us Americans. So we know hate and bigotry. We work to counter anti-Islamic and Islamophobic bigotry every day, and similarly stand beside our Jewish brothers and sisters in the fight against anti-Semitism. Let's be very clear. Anti-Semitism is very real. It's one of the great evils of this world and has been manifested in some of the most horrific and insidious atrocities throughout history and to this day, like you've heard. We must counter and speak out against it wherever it occurs. I believe one of the members of the committee referenced Dr. King, and Dr. King had a famous saying, "Injustice everywhere is a threat to justice everywhere," and we at CARE absolutely believe that. However, that's not what HB 30 does. HB 30 codifies a conflated perception of what anti-Semitism is to potentially interpretation to carte blanche support of each and every action of the State of Israel. And in doing so, denying and infringing upon Georgians' constitutionally protected right to free speech. It's not just us saying this. Kenneth Stern, the original author of the IHRA definition, has argued against its adoption. And in fact, the IHRA was never intended to be adopted for this very reason, because it does infringe upon the right of free speech. It was meant to be a guiding principle for intent for hate crimes. Unfortunately, and I reference line 45 and 46 of the bill, it is not just crimes what this applies to. It applies explicitly to all state departments and agencies shall consider anti-Semitism as evidence of discriminatory intent for any law or policy in the state which prohibits discrimination, which, similar to another committee member who mentioned employment. If there is an employer that has an anti-discrimination statute, potentially using critique of Israel could be evidence of discrimination and anti-Semitism for that employer, and they could be removed. I had the great fortune of being a student of Professor Deborah Lipstadt, who is the current special envoy of anti-Semitism for the Biden administration. She's one of my advisors. She actually wrote one of my letters of recommendation. And she also says, if you call everything anti-Semitism, when you have a real act of anti-Semitism, people aren't paying attention. Similar, when she was talking about critique of Israel, she said that's not anti-Semitism. And it's dangerous to mix it up because it diminishes real anti-Semitism, and it's just wrong. Similarly, just as we are experts in Islamophobia, we are the nation's foremost Islamic civil rights group. We had an incident in Minnesota where a university professor showed a picture of the Prophet. Now, most Muslims would consider that sacrilegious. However, CARE National went out and made a statement that said that is not Islamophobic to do. That is academic freedom. We may disagree with it, but it's not Islamophobia. And we are in calling out what is not Islamophobia, for us is as important as calling out what is. And similarly with anti-Semitism, we want to make sure that when we call it out, we're bold, we're proud, and we stand with our Jewish brothers and sisters and all like-minded friends. And in the same vein, we want to make sure that when it's not anti-Semitism, we're clear about that and protect Americans' rights to free speech. Thank you.
All right, thank you. Any questions? I've got Representative Evans.
Thank you, Mr. Chairman. Could you explain your example that you were attempting to provide on how this would be used to fire someone if they spoke out against Israel?
Sure. So most employers do have anti-discrimination policies in place. Is it okay if I just face you, or should I talk into the mic so you can hear
Talking
me?
to the mic just
Okay.
because we have people listening.
Sure. And so under that policy of anti-discrimination, if one of those employees puts out social media posts and shares amongst their community that, hey, this is something that Israel, the state of Israel is doing. We liken it to apartheid, like President Carter has done, like the Human Rights Watch has done. That could be seen under this definition as anti-Semitic, because it is apartheid by its very nature is considered a racist idea and a racist endeavor, and that is explicitly listed in the IHRA definition. So that employee could be punished and could be disciplined for that social media post, which is speech.
If I could follow up, Mr. Chairman.
Yes.
I believe it's exactly the opposite of what you're saying, is that if let's say, for example, an employee, I think you would have to have the employer criticize Israel or criticize the Jewish people or put a swastika on the wall and then fire someone who was Jewish. And that would be used as why that was a discriminatory firing. I just wanted to make sure you understand that's what's in this bill.
I don't understand that. Could you explain that again? Because I don't think that's a fair reading of what I just explained. So maybe I need to do a better job, but I don't understand.
I think you should read the bill again. Thank you, Mr. Chairman.
Representative Leverett, did you?
Good afternoon.
Good afternoon.
So, again, I'm kind of following up on the same theme I pursued with the last witness. Is your primary concern about the IHRA definition, the provisions that, in your view, might allow legitimate criticism of the state of Israel as a country and policy of the state of Israel to constitute anti-Semitism?
Absolutely. That's the majority of the basis of the concerns, but there are others that some of my colleagues will talk about too.
Okay.
But that is a majority of the free speech issues are in those two provisions, which are 2 points of the IHRA definition. And I will suggest to the committee that perhaps the reason why they don't want the IHRA codified in the actual text is because they know those 2 provisions would most likely be taken out if people explicitly saw them.
One other follow-up. So would removing some of the references to criticism of Israel in that definition address a large degree of your concern with the bill as drafted?
Absolutely. It would make it a much more palatable bill. It would make it much more reflective of American protections of free speech.
Thank you for your testimony.
Okay. Vice Chair Reeves.
I appreciate you coming, and as I mentioned, I've heard from a lot of Muslim constituents as well as constituents from other ethnic and religious backgrounds about the bill. And one thing I wanted to point out, these anecdotes from schools, they weren't in Gwinnett County. They weren't with Muslims for the most part. You look back at Georgia history, and some of the most flagrant instances of anti-Semitism were not by Muslims. The Holocaust was not by Muslims. So I am paying close attention to all my constituents on the bill, Muslim and otherwise. But I want my Muslim constituents in particular to know that whatever I do on this bill has nothing to do with my views of law-abiding, freedom-loving Muslims who've lived the American dream in Gwinnett County. If I'm doing something in favor of this bill, it's to fight anti-Semitism that has its origins with people other than Muslims and its flagrant examples. So I want you to know that your voice is being heard and reviewed, and I'm reading every word of this bill. But anti-Semitism in Georgia is not about Jewish people and Muslims. There is a much larger issue, and that's what we're after on this bill.
Absolutely. I appreciate that, Representative Reeves, and to the committee as well. Again, this is something that needs to be addressed, and I appreciate the intent in addressing it in both by all the bill sponsors, and Chairman Carson's left at this point, but for all of them, because I appreciate this is something that needs to be addressed. We may disagree on how to do it, and that's what this conversation is for, but I absolutely do appreciate that this is something we do need to address.
I don't see any, well, I do. Representative Kelly.
I'll ask you the same question I asked Mr. Small before. Can you give me an example of someone being prosecuted solely for a statement they've made criticizing the policy positions of Israel?
Yes, and so we have a list of 7. I can also email them to you so that you'll have them for later. These were all instances of people who were addressed either by their university or who were or other groups that were using the IHRA definition. It wasn't the state using the IHRA definition, but this is also the concern, is that the way it's written, it also applies to policies. And so these are the 7 that I can list. I'll name some of them. So I'll start with the first then. Following the adoption of the IHRA definition in the UK, an Israel Apartheid Week event was canceled at the University of Central Lancashire.
Please limit it to instances with American law.
Sure. In 2011, IHRA lawyers filed a lawsuit against the University of California, Berkeley, alleging that speech and activities such as theatrical mock checkpoints and events critical of Israel's policies created a hostile climate for Jewish students. In filing their complaint, they used the IHRA definition to accuse the university and student activists of anti-Semitism. While the court dismissed this the case, the Department of Education, which actually does not use the IHRA, someone did reference that it has actually postponed its use of it, also dismissed the complaint. I didn't. I would ask if I'm.
So no.
Yeah.
Continue. But you just said both got dismissed.
Both were dismissed, yes.
Okay.
After the Trump administration adopted the IHRA definition for all federal executive agencies, pro-IHRA activists used it to file 3 federal complaints against Palestine campus advocacy groups. The Lawfare Project files a federal complaint against Columbia University for allowing SJP, which is Students for Justice in Palestine, to hold events. Columbia University for allowing Students for Justice of Palestine to hold events, and art installations engaged in other speech advocating for Palestinian freedom. A second complaint was also filed against Columbia within a week, and a third complaint is filed against Georgia Tech by the right-wing Christian Evangelical American Center for Law and Justice after a student group successfully appealed the punishment they faced for refusing to allow an employee to disrupt their event on Palestine, and those were successful. In 2020,
What do you mean by successful? They were prohibited.
They were not. So they were prohibited from holding those events at Columbia. In 2020, the Trump State Department was planning on designating Amnesty International, Human Rights Watch, and Oxfam International as anti-Semitic. Because of that Human Rights Watch report that came on that said what Israel is engaging in occupied territories is apartheid. That's what the Human Rights Watch said, and so the State Department was planning on designating that until the election. Which obviously there's a new administration then. In 2021, the University of North Carolina was forced to remove a graduate student lecturer from teaching a course on Israel-Palestine after claiming the instructor's criticism of Israel was anti-Semitic under the IHRA definition. And there are other examples as well, and I can share them with you via email. They're just lengthier, so.
That it?
Yes, sir.
All right. All right, I don't see any other questions. Thank you for your presentation.
Thank you, I appreciate it.
All right, next I have up Gary Flack. I got to keep remembering to do this. All right, Mr. Flack, if you would introduce yourself and any organization. I think you're here as a concerned citizen. Is that correct?
That's correct, Mr. Chairman.
You may go ahead and start.
Thank you, Mr. Chairman, and members of the committee for permitting me to speak. I am an individual who has lived in Atlanta for over 50 years. I am Jewish. I am as opposed to anti-Semitism as anybody in this room. I was bar mitzvahed. I was a member of the temple when my children were younger, not today. I want to make 2 points about HB 30. The first is that, in my opinion, it is unnecessary. You all passed a hate crimes bill in 2020. The Civil Rights Act of 1964 prohibits discrimination based on race, color, or national origin, and that protects people. I mean, it outlaws anti-Semitism, in my opinion, and there's been a certain amount of discussion here today about the policy of the Office of Civil Rights of the U.S. Department of Education. It issued guidelines for anti-Semitism this month, and I have a copy of it which I can give each of you. It's a 2-page fact sheet, and commentators were surprised that it did not use the IRA definition of anti-Semitism. Instead, it outlined it outlined examples as to what protections they were concerned about. And they said their protections apply not only to Jews, but also to Christians, to Muslims, to Hindus, to Sikhs, to Buddhists. It applies across the board. So I don't think we need a law that just deals to protect Jews. I think everybody needs protection, and it shouldn't be, you should write a definition that protects all individual groups. By singling out anti-Semitism for additional protection, what about Asian Americans who were shot in Buckhead or North Buckhead? Black Americans, Catholic Americans. I think everybody needs the protections that are intended by this statute. My second point is, if you want to if you want to regulate anti-Semitism, this is not the way to do it. This definition is overbroad, and because I've used up my time, I'll let others here address why it's overbroad. But you've heard from some of the comments already that the concerns that people have and how the definition has been used, whether in Columbia or North Carolina.
All right. Thank you,
wherever.
Mr. Flack.
Thank you.
All right. Any committee members have questions? All right, sir, the board is clear, so thank you.
Thank you. Do you want this fact sheet?
If you want to hand that out, you're
Sure.
welcome to do that. Sir, if you want to give it to my associate here, you'll take care of it.
It's a one-page, two-sided document.
Mr. Chairman, I do have a question for
this
witness.
Mr. Flack. Vice Chair Reeves.
Mr. Flack, you mentioned you're a former member of the temple.
Yes, sir.
What's your understanding of the reason that the temple was bombed in the 1960s? Why did the perpetrators choose to bomb the temple specifically during the civil rights era?
I think it was 1958, to be precise. So I think the reason was they were concerned. The short answer is anti-Semitism, but I think people were also concerned about Jews helping Negroes in the civil rights movement, to use the language of the time.
All right. Anyone else? All right.
Thank you all.
Yeah, thank you, sir. All right, I'm probably going to mispronounce this name too. Beth Gan or Gaan? Gan. All right. I told you I'd get it wrong.
Okay, this is a little intimidating. Okay.
I'll let you get settled in.
I hope I don't cry.
All right, when you're ready.
I just need, okay.
Ready to go?
Did I just talk here? Yes. Hi, my name is, good afternoon, honorable members of the committee. My name is Beth Gann, and I am the mother of the twin boys that were terrorized at school. And I stand in front of you because they are still not comfortable coming up and speaking, and they are still not comfortable with being Jewish most of the time. As you know, my twins were terrorized with anti-Semitic gestures, swastika slogans for 18 months. This is what my son killed the Jews, gassed the Jews, Nazis, Nazi symbols, and then a gun. My kids were fearful for their lives, and I went to the administration. Sorry, I lost my spot. And nothing happened. This was 18 months that bears repeating. It started in December of 2015, and it didn't even end when they graduated middle school. And it happens all the time. I spoke to anyone and everyone that would listen. I reached out, and this was happening. Administrators, teachers, coaches, principals, administration, no one knew what to do. I was, as my friend calls me, the pink elephant in the room. And all this time I was going through breast cancer. My family stood alone. I stood by myself, and as CARE says, they stand by their Jewish brothers and sisters. They were not around. And I was not taken seriously until the Department of Education and the Office of Civil Rights and the school board decided to take action. The Department of Education, which does call about anti-Semitism, said to our state, if you cannot figure this out, we will figure it out for you, and we will pull Fulton County's accreditation. That got me noticed. Because it was never identified as anti-Semitism and taken seriously, the kids were never caught or disciplined. And unbeknownst to my kids, they probably will figure this out now, I had them protected when they went on to high school. They were escorted from class to class for fear that there would be a Hitler salute or something thrown at them. It is what, if there was a definition, I know that this would not have happened. I would have been able to tell them that this, yes indeed, is anti-Semitic and what it is. I also filed a police report. I was told that that wasn't good enough with the time. I ask you to vote in favor of this so my family's suffering was not in vain. Thank you.
All right, are there any questions by members of the committee? All right, seeing none, thank you, ma'am.
Okay, thank you.
Simone Walker? Yeah, you'll be fine.
Hi.
Hi, if
Can
you
you hear
would.
me? Okay. My name is Simone Wilker, and I'm here with my colleague, Dr. Rachel Schoenberger, and we're here today as Jewish women and representatives of Hadassah, the Women's Zionist Organization of America, of which in Georgia we have over 5,500, members, and over 300,000 advocates within the United States. First of all, we're really grateful that you all worked and developed and passed the hate crimes bill in 2020. And so we're here to ask for support in advancing additional legislation that's critical to fighting hatred. Hatred towards Jewish people has been done since ancient times, but today there's an alarming rise in anti-Semitism, particularly in Georgia. Acts of hatred and bias, large and small, in places of worship, in the school settings, in academic institutions, professional settings, deeply affect people's lives. Imagine if your child or you walked into a school and saw a swastika on the wall, or if you're driving up the expressway on 85 and you see a swastika on a sign, a public sign, a speed sign, or if you decided to take a ride to the grocery store and you drive right up the street on Peachtree and you see a billboard defaced with something about being Jewish. How horrifying that would be and how upsetting that would be in your own community. Acts of hatred need to be eliminated. Anti-Semitism needs to be eliminated, but the only way you can do it is to define it first And then you can easily say this is an anti-Semitic act. Without that definition in your hand, it's very hard for law enforcement or other federal officials or state officials to make that decision. Sometimes it's not so clear. So that's why adopting this International Holocaust Remembrance Alliance is so important. The definition is so important, and HB 30 would do that. On a very personal note, I want to say that my grandfather left Nazi Germany because he was persecuted simply because he was Jewish. And he left there with my mother and siblings and a grandchild, and where does he come? Savannah, Georgia. They wrote to the police chief in Savannah because my uncle had a brother who lived there and he didn't know his address, and the police chief got the letter to my uncle, great uncle, and found him, and they said to come to Savannah. So I have deep roots in Georgia here. And I want my grandchildren, who are 7 and 10 years old, Jewish grandchildren, to enjoy the same freedom that my grandfather and all my family enjoyed in Georgia, and being Jewish and not being afraid to stand up and say, I'm Jewish. I don't want my grandchildren to be in the same situation as this other family. I'm very proud to be Jewish, and I hope that you all pass this bill, HB 30. Thank you.
Any questions by the committee? Representative Leverett.
Thank you. Thank you, ma'am, for your attendance today. I enjoyed visiting with you over here earlier.
Thank you.
I hope you'll say hello to everybody in Savannah for me. Does your organization have I know you're in favor of the bill, do you have a position on whether the IHRA definition is incorporated or set out in the bill, or whether there are any variations from it?
So my organization absolutely has a policy statement in favor of the bill with all the 11 examples that are there. Whether it would be included in the bill, I can't answer that. That's for legal people to answer. I can't say whether I would want it there or not.
Okay.
I looked on the website, and it refers to the May 2016 statement. So I did just now look on the website while we were having that conversation, and it looks pretty clear to me that it's there. But I can't answer that for the organization. We do support the IRA resolution.
Okay.
For sure.
Thank you so much.
Okay.
Thank you, Mr. Chairman.
All right. Representative Crawford.
Thank you, Chairman. And Chairman, I don't know if this is an appropriate question for you or anybody, but the question I have is that a court will already analyze the facts of each case to determine whether or not discrimination will exist for protected classes, even if that's not always explicitly defined. What impact will this bill have on judicial determinations, if any at all?
Well, that's kind of been a concern of mine. I'm not sure how that's going to work. In particular with criminal cases, if you've got a hate crime, does this have to be an additional element that the prosecutor is required to prove? That's a concern I'm having.
Thank you.
Okay. Representative Leverett.
Mr. Chairman, just to Representative Crawford, I think he sort of hit on one of the concerns I have. Is I'm in favor of enacting this bill. I just want to make sure we as a legislature do so in a way that has definite enough standards that it can be enforced.
Right. Okay. All right.
Thank you.
Vice Chair Reeves.
And one thing to add to Representative Crawford's question or comment, I believe subsection F of the bill explicitly says no cause of action, so no right or benefit, and so we're not talking about civil litigation.
Okay. And Representative Silcox, I think.
Thank you, Mr. Chairman. I just would add that I think this goes directly to the element of intent in a hate crime. I think that's where it would fall. Thank you.
All right. Thank y'all. I'm sorry. What do you have? Is it 18? Try it.
I'm not sure what number this. Did I understand your comment, Representative Reeves, to mean that if you don't meet the definition of anti-Semitism, you can't be prosecuted for hate crimes? Is that the center of what this discussion is about?
I think Representative Crawford asked about litigation, and this pertains to criminal matters and discrimination, but it doesn't create a private right of action, in my understanding.
So I'm asking another question. Does the failure to meet the definition of anti-Semitism constitute a barrier to a hate crime prosecution? That's my question. I don't know the answer, obviously.
Hang on, hold on.
I would hope that what we're doing would play, if someone commits violence against someone on the basis of anti-Semitism, I would hope that there would be criminal penalties for that. In response to that question about civil litigation, I just wanted to say, in my reading of it, I wanted to make sure we're not talking about creating a private right of action for a civil case, but definitely criminal activity and violence. That's what I understand we're talking about, having this, as Representative Silcox mentioned, intent for a hate crime or other criminal penalties. That's what we're talking about.
I know that's what we're talking about. I'm trying to figure out the answer to my question. But
My reading of subsection F, or my personal reading of subsection F, it's my understanding we're not talking about creating a civil cause of action. That's based on this current legislation.
I'm waiting to hear the rest of the testimony before I make up my mind.
Thank you, Judge. Thank you, Judge.
Representative Crawford, hang on a second. There you go.
Thank you for clarification, and thank you, Chairman and Vice Chairman. I wasn't asking about, I was asking about judicial determination, period, whether that be criminal or civil. So I just wanted to clarify that.
All right.
Mr. Chairman?
Oh, sorry.
As a point of personal privilege, the two ladies who just spoke belong to Hadassah. I've been a member of Hadassah since I was born, when my mother made me a member. My mother and grandmother have been members. I'm the third of 4 generations of life members of Hadassah. We have many women here who are, and I've been a proud member all my life. And so we have always taken a position on issues like this, especially as it relates to anti-Semitism. And I'm proud to be a member, and I'm proud to see the women here today. Thank you.
Thank you. All right. The next two, I'm not sure will still want to testify, but you may want to add something. You had a letter, and it's in the folder of each of the members of the committee. It's the Aaron and Alex Bedlitz. They're good? Okay.
Thank you.
All right, thank you. And thank you for the input with the written letter also. All right, took my glasses off. Dr. Elise Cohen. All right. When you're ready, if you would introduce yourself, and if you represent anybody, let us know that. All right.
Sounds great. Can y'all hear me? Okay. Mr. Chairman and committee, thank you so much. Good afternoon. My name is Dr. Elise Cohen. I'm a Sephardic Jewish Georgian, born and raised here. My grandfather was the rabbi of the Sephardic synagogue. I'm a Jewish studies and Middle East educator, scholar, activist, and writer, and a Jewish life cycle facilitator. My research has specifically been focused on the experiences of Sephardic and Mizrahi Jews, Jews from the Middle East, Southwest Asia, and North Africa, in Israel, specifically around eviction, war, discrimination, and social movements. For almost 20 years, I led North Americans on delegations to both Israel and Palestine to meet with human rights defenders, scholars, activists, and communities to see for themselves what's happening in Palestine under Israeli occupation, as well as to understand what's happening inside the internationally recognized borders of the State of Israel. In addition to my years of research and leading delegations, I lived in Israel during high school, for university, and another 2 years while working in the Palestinian and Jewish sectors of Israel. It is a bit bizarre, as a Jewish person, to be asking you to oppose an anti-Semitism bill, HB 30. However, this bill is attempting to codify a working definition of anti-Semitism that was supposed to be used as a tool to discern what anti-Semitism is, not as a concretized definition, as y'all have been bringing up. And bills like this create harm, even to other Jewish people, and do little to curb or undermine the roots of anti-Semitism and its threats. I myself was accused of being anti-Semitic by my former dean when she told me that the community, the Jewish community, was calling in, even though I was the only Jewish studies professor at the university, and that was here in Georgia. I'm here also to note that clearly there is not a consensus among Jewish Georgians on the definition of anti-Semitism, which that alone should raise a question. The International Holocaust Remembrance Alliance's definition of anti-Semitism includes several examples that tie Jewish identity with the State of Israel. And I just want to say when it was read, was that somebody else's? That was somebody else's. Okay, can I get my time back? Because I just want to say that I know when the definition was read out loud, the examples that everybody wants to put in it or that are suggested to be part of it actually were not read out loud, and that's a significant part of the definition. In the definition, self-determination of Jewish people, for example, is linked to the State of Israel, which as a Jewish person forces me to have Jewish self-determination defined for me by Georgia law and forces an unfair loyalty to a particular country that is not my own. It also specifically singles out Israel as a state to be treated differently than any other state or country. To me, the bill itself is an example of anti-Semitism rather than a fight against it. Though the bill suggests no double standards should be applied to Israel, the bill is doing exactly that. It singles out Israel from all other nations, codifying that we as U.S. citizens, and more specifically Georgians, have the right to do, say, or act when it comes to being critical of Israel in the ways we would be critical of any other nation, including our own. In fact, the definition that says that Israel should not be held to a double standard or expect something different from it as any other democratic nation. However, the bill does not mention, not even once, that anti-Semitism does not include being critical of and working against the almost 56-year Israeli military occupation of Palestine, which in itself is anti-democratic. Take this example. There's no reason for the state of Georgia to protect one country over other 195 countries in the world. Imagine if a similar bill attempted to silence debate about China's human rights records, about the occupation of Tibet, the horrific treatment of the Uyghurs, by providing a legal basis to claim that such criticism must be motivated by anti-Chinese racism, and therefore constitutes a hate crime. And Georgia law, I hope you would agree, should not tell us what we can and can't say about a foreign country. We, in the Civil Rights Code, as it was mentioned, Jewish people are protected as other, trying to go fast, as other minorities in this country. So we don't need a specific one to single out Jewish people, tying it to the State of Israel, and also silencing us in our rights to speak out freely, as well as for others who have had the same right to be critical of Israel and any other country, including our own. And for what is democracy without these rights? It was already mentioned about the U.S. Department of Education Civil Rights Code and how they made sure to show how Jewish people are protected, which was handed out by another person. I spoke with Kenneth Stern yesterday, one of the original and lead drafters of the IHRA definition, who has been working tirelessly to help federal, state, and other officials understand how IHRA definition should not be codified into law because of the way it chills freedom of speech. He explains that enforcing it as a definition to focus on pro-Palestinian speech in Israel misses the drivers of anti-Semitism. And this is not at all how the definition was intended to be used.
Dr.
A host of Jewish organizations, yes.
How far are you from wrapping up? I need to treat everybody
not
equally
far.
if I can.
Not far.
All right.
Thank you. A host of Jewish organizations oppose its adoption. National organizations, the Progressive Israel Network that includes J Street, New Israel Fund, Americans for Peace Now, Truah, which is a rabbinical civil rights organization. Legal experts, 40 civil rights organizations, including the ACLU, are opposed to the adoption of IHRA, calling out IHRA's impacts and its effects on First Right amendments. Holocaust, Middle East, and Jewish studies scholars nationally and internationally have sounded the alarm bell, explaining their concerns about the repercussions at universities for their students and in quelling free speech. The Canadian group Independent Jewish Voices, who works in coalition with Jewish groups across the U.S., has 11 pages of examples of how IHRA definition has already been used to squelch free speech all over the country. So passing this bill will not only silence Palestinian advocates, it will also silence people like me as Jewish educators. It will silence a whole generation of young Jewish people who are the life of our community, and Israeli colleagues and lawyers who are also opposed to it. This bill, like other bills that specifically target minority groups in our country is not making it safe for us as Jewish people or any of us, but actually reinforces the separation of Jewish people from other groups that experience forms of hatred and violence. Passing a bill to claim that is to combat Semitism when it actually silences free speech and imposes an anti-Semitism upon us is dangerous, and I urge you to oppose HB 30. Thank you for your consideration.
Thank you, Dr. Cohen. You have a question from Vice Chair Reeves.
Did you mention that there was a school in Georgia where you worked where the dean took action relating to anti-Semitism?
Yes, my contract was not fulfilled.
What school was
Agnes
that?
Scott College.
And that dean was taking an action against perceived anti-Semitism.
Correct.
Okay.
What I'll say it,
And
I'm just going to say how she said it to me.
No, don't worry about it. Just wanted to see. I'm trying to get all the incidents and just see where is it coming from in Georgia. And in that one, that's the first one today where someone is taking an action against anti-Semitism. We hear of inaction. That was one where maybe you think there was too much action. Second question, I did read the paragraph that's the introduction. You said maybe I should have kept on reading and asked the other 11 items that are examples, but those are subsections of the paragraph I read, right?
Well, so part of what's been asked is that the definition include the 11 examples.
Right. The 11 examples are subsets of the paragraph I read that mentioned violence.
It's
or
still
physical
part of this whole. It's being asked for all of that.
Breaking somebody's window, or otherwise assaulting people or property. That's the introduction, and then the subsection of those 11 items are in conjunction, or they are subsets of the introduction.
I think I can't say that because when it's being asked to come forward and say it should be the accepted definition, including the examples, and we heard from Representative Carson about how that has been changed to specifically make sure those examples are there, then that to me says that that is a substantial part of the definition. It's not just as a subset, but it gives indications about how to define it.
But the 11 instances, that would be in conjunction with an act of violence or a physical manifestation. That's what the definition says.
I think this goes back to the question about whether or not it is about free speech, and the examples that CARE gave, for instance, were examples of that. And I also want to give two other personal examples.
Well, let me ask you this.
Okay.
You would agree it's not free speech to beat somebody up, right? That's not speech.
Of course not.
All right. And breaking someone's window or another physical manifestation of violence, that's not free speech, right?
Right.
All right.
Actually, I want to say that in acts of civil disobedience, they might look particular ways. And so acts of civil obedience might be to do something like trespass a property or something like that. So I feel like the legal experts are the ones that are going to define this. But I do want to add that I think another part of in a personal story, it's interesting Hadassah is here, which, is a famous organization, is of course done amazing work. And at the same time, I can say that as an academic that I was invited, I remember this years ago, was invited to talk to a Hadassah group locally. And once they found out that I was going to talk about what I was going to talk about and could potentially be critical of Israel, that the offer was rescinded. I also see this for my 13-year-old who at school happens to have done a project on social justice issues, and they chose to do something on Palestine. And then at school, they were targeted for having been anti-Semitic because they were raising issues of Palestine, even though they are a Jewish child and they are self-identified as Jewish and they are part of this community. So I think that it's, across the board, we have an issue that we need to address, but not necessarily to separate Jewish people, nor to keep and have examples that are about being critical of Israel or something that is not a consensus in the Jewish community nationally and locally.
Representative Leverett.
Thank you, Mr. Chairman. Thank you, ma'am, for your testimony. And I admit I'm cheating because I got the definition in front of me, which you don't, although you sound like you're very familiar with it. So one question, I suppose, is my sense is you're concerned that adopting this definition, you have some other problems with it, I understand, just sort of structurally. It's not intended to be a legally binding definition. It certainly might have impact, criminal law, et cetera. And I understand that. But it sounded like the biggest opposition or the biggest concern you have is its potential use to stifle legitimate discourse about policies of the State of Israel. Is that fair? That's one
Correct,
you read?
because I've seen it with my students
Yes,
and with
you-
colleagues and universities and myself.
You've
Correct.
got personal experience
Yes.
with it. If we were to excise some of the reference to Israel in the definition, would that address, and not just that word, but the topics that refer to the state of Israel, would that address a lot of your concerns about adoption of this definition?
So I want to answer your question, and I want to also say that I think what's hard is when you start with a definition that is severely problematic, and then you start taking away the pieces that are problematic, but you don't actually look for the definition that would actually work well, then it makes it harder to do it. It's kind of like starting with a document that you really dislike, and then you don't get something you necessarily want. So yes, if all the examples were gone, including the ones about being critical of Israel, because we should not be talking about a foreign government or a state anyway. And I don't know why why that would even be part of Georgia law when we're talking about Jewish people and Jewish residents of Georgia. So that's one thing. And then the other thing is to say there's many definitions. So the Jerusalem Declaration, which are scholars from all over the world that have talked about an alternative to IRA. There's other definitions beyond that. And so maybe it's a combination of talking about those things, but the other really important point to me is that if you give Jews or Jewish people a special privilege of being protected while other groups are not as protected, and I'll give an example. So I think there was a bill that was passed last year about making sure that there were not free speech zones, but there was a very strong push to make sure that there was free speech everywhere. And so if we're doing that, then let's be clear about that across the board. Don't separate one group out in what we can critique and not. I also want my people protected. I want every group protected. I think clearly most of us do not want to see violence and hatred and bigotry toward their group of people or any other group of people. So we can agree on that. I think the other part is when we're talking about this, I just lost my train of thought, but I will get there. About the definition.
Yeah.
So I think that's what we're talking about. I think the other part of the definition is that that because there's not a consensus, if our Georgia legislature is going to pass a bill where there's not consensus, even by Jews, nationally, locally, about this, then how is that protecting Jews when people are all calling concerns to that? Mm-hmm. And that's an important conversation, and I think it's really, really hard. I mean, I was terrified to be here. It's very hard to come here and say, take 3 minutes and talk about your people and what you're concerned about and how to fit it in within the framework of what are we actually concerned about? Are we actually concerned that people will get, the horrific stories about being at school and anti-Semitic stuff happening and nobody doing anything, that school should, people should have acted all across the board, clearly. I don't think there's a person in here that would object to that or that would want to see something different. But if we're actually going to do something, then I think the discussion has to be more thoughtful and engaged and not just accepting, and again, a working definition. You were one of the people who said the working definition is a working one. If it changes, we're also, I also hear that there's arguments, codify how it looks now, don't change it. To me, I say, if I'm worried about the critical of Israel part and how it's already impacting, there are colleagues who would not sign a letter because they know it will impact them professionally. There are students who would have loved to advocate, to be here today, and they're terrified. And so as a teacher and as a Jewish person, I don't want them to be scared of that. I've already been affected professionally. I don't know what else folks can do to me. But for them, I want something different.
Well, and I will certainly agree with you that testifying before this rogues gallery is an intimidating process. And I appreciate your coming forward today. But I think the answer to my question was no. While that would help, it doesn't address the concerns you have about use of this definition in a statute.
If you gave me a choice about, look, you have a choice of having with the examples or not having with the examples, I'd say, do not do it without the examples. That is harmful. If you ask me the more authentic question, which is, how are we going to address anti-Semitism across the board, along with racism and other forms of bigotry and violence toward all the minority groups, then I would say we have to start on a much deeper level about getting to the roots of why people even have the beliefs they have. And I don't see that happening in schools. I don't see us taking a point to do that.
No disagreement there. I do think that's a discussion we need to have, but I think this, just like with the Civil Rights Act, that was a place to start, at least in trying to change behavior and having a way to impact behavior through government action. And so just to clarify what you said, are you saying you would feel, I know you don't like the definition, and I understand that, and I'm not trying to suggest you do. And I also think you don't believe that making some edits here and there really solves the fundamental objection you have to use of that definition. But I guess I'm just asking, would removal of the references to legitimate criticism of the state of Israel make you less uncomfortable about the use of that definition? Is that it seems to me that's a big part of your concern about the use of that.
I would say that yes, those examples about criticism of Israel, or how we're supposed to think and talk and believe about a foreign country. That should not be in our law at all, in Georgia law, across the board. Whatever group it is.
I understand it. One final question. And to that similar, I'm asking more structural questions here. Did I understand you to say that you don't object to some of the other examples? You think they're actually helpful, or you have a problem with use of the other examples in the definition as well?
Do you want my honest answer?
Yeah, absolutely.
Yeah, I think my honest answer is, I feel like this is one of the things where, like, it puts me and others on the spot immediately to try and give you good reasoning when I just read this thing to you, and I would want to look at the definition, and I'd want to sit with all my.
I don't know.
No, I'm not. Please just hear me. That it's not. I feel like that's important. I mean, if you told everybody in this room who's pro and against to sit down and say, what are we going to do to solve this, and we're going to push it back to you to make that happen, and how can we make sure people are not going to be harmed in our state, then I would say that would be a beautiful way to handle it, because you're saying this is an issue. We have to address this. Figure out how to make it happen, come back to us, and let us have something that really does work, where there's some kind of consensus on it. Right now there is not, and I can't answer the question because I have it in here somewhere in these papers, and I can't find it, and it's freaking me out.
I don't mean to put any pressure, I'm just trying to gather information.
Okay,
So
well, hopefully you got some of it.
I did, yes, ma'am.
Okay.
Representative Evans.
Thank you, Mr. Chairman. The example that you gave where you felt like you were professionally hurt and were accused of anti-Semitism, did that, in that experience, did the person that canceled your class, I can't remember exactly what it was, did they tell you that they were using the IRA definition of anti-Semitism to say that you were being anti-Semitic?
They told me that the organization was behind it, and this is what I was told. So folks who are here with AJC, please don't freak out. But what I was told was that it was people who were connected to the American Jewish Committee who called and called and called to make sure and say, why is that professor, who's the only professor teaching Jewish studies, why is she teaching when she is anti-Semitic? And that had to do with, I was the only Jewish studies professor. So I was teaching about Judaism. Some of the, if there are rabbis in here, some of them were probably invited to my class to talk. But that what she said is they're saying that you're anti-Semitic. And all I could say is, what is the relevance of this right now? Because anything I did about Palestine or Palestinian advocacy was not necessarily in the classroom. But if I was talking about human rights, we were talking about Israel and Palestine. So that's the only way I can answer it is I was being told by a university that they were getting calls from the mainstream Jewish community in Georgia. Why was I teaching this class? Why was I there? And that the result of that was her telling me in a conversation and then not having my contract renewed.
But it doesn't sound like, from what you're saying, that anyone said, we find that you are acting in an anti-Semitic way, your class is anti-Semitic, based on the definition from IRA.
Well,
True?
the IRA was not circulating in the way it is now, but we also know that IRA and the concepts around it have been circulating since 2010 and 2011. And as Kenneth Stern said yesterday, who again was one of the leaders and drafters of this working definition, he said it really has been taken out of context and is being misused to focus on something totally different, which is about talking about advocacy of Palestine rather than actually talking about anti-Semitism. And Kenneth Stern and I are not necessarily in the same place politically. But I'm saying that somebody who was a drafter and who had the intention of addressing anti-Semitism and did this on an international level, both looking at it in Europe and in the United States, and for the AJC, is someone who is concerned and doesn't want to see it happening like this, and was eager to find a way to stop this way of addressing anti-Semitism.
I would commend you for coming. We appreciate it. I would also commend to you to look again at what I believe is the heart of this bill, which is lines 45 to 50, that talks about how you could ever use the definition of anti-Semitism. And I would also suggest that perhaps because of the situation that you described, it might be good for us to have a definition, because it sounds like in your situation, someone just decided that they thought you were being anti-Semitic and they weren't basing it on the definition here. And I would just submit to the committee, perhaps, maybe this is an inappropriate time, Mr. Chairman, and I apologize, but this is exactly why we need a definition.
This is out of respect, Mr. Chairman. Out of respect for how you frame that, I would say it's the exact reason why we don't need this particular definition, and how it harms Jewish people also. And so nobody's going to be able to help me professionally. However, I can speak out. And I think trying to quiet is the exact reason why this bill is problematic. So that's, that I feel like it's unfair to, I feel like it's an unfair thing to say that. Is somebody hissing?
Yes, somebody's hissing. A lot of people
I'm not here.
I'll try not to say anything more about that. It's really disrespectful.
I didn't hear that.
Yeah, there was hissing.
All right. Be careful what you're doing, because I can get you thrown out of the room. So just fair warning.
That to me was the exact reason why free speech is what's happening.
All right. Any other questions from members of the committee?
I have a question for you.
Representative Bruce?
Because what appears, and again, I'm not a lawyer, but what it appears is happening is that we have one group saying that we need a definition, and I think we do need a definition, but then the other side is saying this isn't the definition. So I guess, I know you said we're going to vote on this, but should we not consider making sure that we're a little closer, because I'm hearing people say, I want to support the bill, but I don't agree with this. I want to support the bill, but I don't agree with that. And if you ask us to vote today while people don't agree with all of this stuff, it just seems like it's not the right thing to do. We need to have a little more consensus.
Do I hear any motions or any discussion about what you want to do with the bill at this point?
Well, if it's appropriate, I would move that we continue to consider the bill, and that we continue to do the things that we need to do, but not vote today, because even the committee members are saying, I want to support it, but I don't like this. I want to support it, but I don't like that. So let's fix it. Let's get it to where we can be comfortable voting.
I agree.
Mr. Chair.
All right. Representative Holcomb.
Thank you, Mr. Chairman. I want to make sure that I understand it. I think that's true for all of the members. And initially, I thought that it was just in the discrimination context of a civil suit, or to help define the hate crimes should the victim be a Jewish person targeted because of anti-Semitism. I want to have a better understanding of the potential for a chilling effect on our university campuses and otherwise. If the answer is no, it doesn't do that, then just let me know that the answer is no, that it doesn't do that. If it does, then I want to have that understanding too. But that's the part that I still have a little bit of lack of clarity that I'd like to have more clarity on.
I understand, and we're still hearing from folks that want to talk on the bill. We haven't gotten to that stage where we discuss what we want to do with the bill.
Right.
So let's just be patient and work through the process here. All right, I don't see any other questions. Chairman Smith, did you have anything? Okay, all right. Thank you, ma'am. Appreciate your testimony.
Thank you.
All right. We got several more to go through. I'm getting ready to lose some of the members of the committee, so we really need to move through this pretty quickly if we can. Rule R.B. Willis. Hi.
I was relaying to someone earlier. I used to work here as a reporter, and I remember sitting right here when I had a nosebleed in the middle of a session, and some lobbyist was like handing me tissues while I was like taking notes, and people of the committee that I'd never met before, because I'm nervous about speaking to people, came up to me afterward and were like, "Are you okay?" And I was like, "Yes, Representative, I'm fine. Thank you for taking the time to talk to me." So it's just funny being back here. My name is Ruel Ari Willis. I go by the moniker REB. That's how you'll find my writing. So I wanted to share something that happened to me here, and also I think I kind of want to address my community. So Crossover Day 2017 was on a Friday, which meant we were going to midnight, which meant Shabbat was going to start. So I asked a rabbi friend and some other folks in my community if they could come down here and support me in having a small Shabbat ceremony. And as you all know, it's a little crazy when everyone's like, "Well, when is it going to be?" And I was like, "They haven't announced dinner yet. I don't know. I'm really..." Are they telling you when? No. No one's telling me anything. This is going to happen when it's going to happen. So we were up in an empty committee room up on the top floor, and the staff next door was watching us on the cameras, which I found out because I went into the room to offer them some of the cookies that we had, and I saw that we were on the screen. They declined. Then they came in later. We had my friend had planned like a 30-minute service because, I'm not sure how long dinner was going to be, if there were going to be press conferences I needed to get to. Sorry, I will make a long story short. They ended up calling the state troopers on us, and me and about 5 other people thankfully the state troopers knew me because I'd been here every day, and so when he saw me, he was apologetic about the experience, but was like, you can't be in this room. You need to have requested to use the room in advance, and all the things that I had not been aware of in that moment. I think the state troopers called on us because they didn't recognize what we were doing. When I come here, when I worked here, we pray to God every day. And we pray to the Christian God every day. And we pray to that person before committee meetings on the House and Senate floor. And so when I was there with my tzitzit and our little cups of grape juice and saying words in Hebrew, the very good Southern ladies who were working in that office didn't know what we were doing, and it made it scary. And so they called the state troopers on us, and we were escorted out of the room. That being said, I just also want to hold in my heart all of the fear that everyone in this room is naming. Holy shit, it is hard to be a Jew in this state. It is hard to be a Jew in the South. So many of us have stories of our parents being asked about their horns, being called the N-word, of family members who hide being Jewish because they wanted to access the safety of pretending to be a waspy white person when that's not necessarily who we are. I'm so grateful that I can be here and just be a smidge public about who I am, because I only found out when my grandmother died and I was walking to her funeral that most of her friends didn't know that she was Jewish because they were so anti-Semitic, they wouldn't have allowed it. They would never have let her in the country clubs if they had known that she was a Jewish child and that her family were Jewish. This is a real thing, and I hear your fear and it breaks my heart, and I'm in my own fear and it breaks my heart, and I wonder if this body is the right place to address this, because we are still in a place where people don't understand what Judaism is. We're still in a place where pastors come and speak on this floor every day about the Jews and the people of the Torah like they're dead. We still have monuments to the people who lynched Leo Frank on this Capitol ground. So forgive me, but I don't think this body is the right place for this legislation to happen. I think what I need from particularly the Christians in the room is for you to go into your communities and talk to your preachers and pastors about why they are still teaching that the Jews killed Jesus. I need you to go into your communities and say, I will not accept money if you're going to come out here and say that the Jews are getting what they deserve in closed room doors because they never accepted Jesus in their life, because that stuff still happens here in the South. These are the places you have influence that I have no access to. Please speak to your communities, speak to your staff about what religious minorities are like. Help us change this, but don't try and put this complicated and controversial definition into law as a way to resolve this issue. Thank you for your time.
Questions by the committee? Seeing none, thank you.
Thank you.
Eric Robbins.
Thank you, committee, for your time. I'll be very brief. I know you have a lot going on. I'm Eric Robbins. I'm the president and CEO of the Jewish Federation of Greater Atlanta, an organization of over 100 years old, representing the larger body of the Jewish community of Atlanta, which, by the way, today is about the 9th largest, maybe even larger than that, Jewish community in North America. 150,000 Jews here, with probably another 50,000 Jews living in Jewish families. I am in favor of the bill. You heard many of the examples why, so I'm not going to give you any more. We think the IRA definition is widely accepted. We think that it's also, it does not infringe on free speech as the law is written to protect the First Amendment rights. We think this is another step to help us address anti-Semitism, which, by the way, we know what's all going on, but I'm sure many of you also heard of the Molotov cocktail dropped at the door of a synagogue in New Jersey. So this is just an issue that we need to do everything we can to address. So thank you for your time.
All right. Any questions from the committee? All right. Thank you, sir. Wayne Kyle.
Good afternoon, Mr. Chairman, members of the committee. I'm going to go off script for 1 second here because I've been taking some notes, and I want to try and get this back on track a little bit if I can. First thing I'm going to read is from the definition itself so that we're very clear on something. Criticism of Israel similar to that leveled against any other country cannot be regarded as anti-Semitic. It says it right there in the definition. The definition actually protects criticism of Israel. So I just want to put that into context right away, because I think that the committee is hearing from people who have not quite read the definition. My name is Wayne Kyle. I am the CEO of Hillels of Georgia. Our organization manages 24 campuses across the state of Georgia that serve more than 5,000 Jewish students on those campuses. It is our job to make sure that those campuses, whether student-driven or professionally driven, have the resources that they need. One of the most important resources that we can provide is safety. We work tirelessly with the administration of our many campuses to forge relationships and build bridges so that when something comes up, we have the ability to quickly respond. Our students on our campuses are subjected to incidents that do not make the news, but are terrifying for those students. The recent Kanye West saga illuminates what our students deal with on a regular basis. We are all familiar with the UGA-UF game where a laser display posted, "Kanye was right." Imagine being a Jewish student at UGA or UF and coming out of the game and seeing that. Now, through our excellent relationship with the UGA and their administration, we were able to get statements out the next morning condemning the incident. But you see, the situation doesn't end there, because now we have a group of people going from campus to campus, putting up a booth that says, "Ye was right, prove me wrong." That is intimidation. Now, too often our students are discriminated against, told they cannot join a club or run for a position, and they are hit with the following: "Oh no, I'm not anti-Semitic. I'm anti-Israel, or I'm anti-Zionist." This is disingenuous. Telling Jews that it is okay to discriminate against them and harass them because a part of their Jewish identity involves support for the Jewish homeland is anti-Semitic. I'm going to continue if that's all right. I'm going to do my best. I hear you. Anti-Semites do not get to define what Jews believe. Our core beliefs as the Jewish people is that we have a right to exist in our historic homeland. The vitriol our students experience on campus is not directed at the Israeli government, but at innocent American Jewish students at Georgia universities. Why? What do they have to do with the Israeli government? Why is it that we cannot disagree with Israeli policies without following that it is okay to discriminate against anyone who supports a Jewish homeland? And it's not always Israel. Our students are subjected time and again to swastikas in bathrooms and other public spaces. One of our students was harassed by his roommates for being Jewish, threatened with violence. The escalation of anti-Semitism is not something that is up for debate, right? It's something happening around us on a daily basis. How we choose to respond to that escalation, that's entirely up to us. The bill helps us respond. It sets a standard, and that's what we need. If we don't draw a line now, we won't be able to draw one in the future. I can't tell you how many times I have been in meetings with universities who try to claim that anti-Semitism doesn't fall under Title VI because Jews are a religion and not a national origin or race. Well, our students are not being harassed and bullied because they light candles on Friday nights or pray in Hebrew. They're being harassed because they support their homeland. The Department of Education has made it clear. The bill in front of you allows a standard to be set at the state level. It's very simple. I would ask you to respectfully vote in favor of this policy.
Thank you, Mr. Kyle. All right, Representative Holcomb.
Thank you, Mr. Chairman. First, I think Kanye, or whatever his name is an idiot. So let's just start with that. Secondly, can you give me concrete examples of how this protects the students on campus? I want to understand how this is operationalized.
So I'm going to give you here's a perfect example. And Mark Goldfeder mentioned it earlier, Samantha Strelzer. Samantha Strelzer is a graduate student at Emory University. She went on Birthright. That's it. She went on the Birthright trip to Israel, had a good time. When she got back, she was accused of supporting genocide, among other things. She was publicly harassed. Oddly enough, the person harassing her was a fellow student government person who was the chair of student government for diversity, equity, and inclusion. The university had no idea what to do. I went into the meeting and they said, oh, no, this isn't Title VI, this is Title IX. No, she wasn't being harassed because she prays in a way. She was being harassed because she went to Israel. And she was being harassed because she was Jewish. And somehow that conflated everything. So she was being held responsible for Israel's policies because she was Jewish. And that is anti-Semitism.
Okay.
Birthright, fair. Birthright is a trip for young Jewish adults who have never been to Israel to go to Israel for 10 days and experience Israel so that they can have unfiltered knowledge, not what comes out in the news and not what people would say.
Okay, all right. Thank you, Mr. Kyle. Thank you. All right. Rabbi Daniel Dorsch. He left. All right. Scott Zucker. Mr. Zucker. I'm trying to stick to this as best I
I
can.
appreciate that. I'll move quickly.
Thank you.
Mr. Chairman, members of the committee, my name is Scott Zucker. I'm the co-chair of the Civil Rights Committee of the Anti-Defamation League, Southeast Region. As all of you know, a leading hate organization, anti-hate organization committed to stopping the defamation of the Jewish people, securing justice and fair treatment to all. I have to work off, you've heard a lot today. Representative Kelly said something to begin that we're not going to solve bigotry today, but boy, y'all can make a big difference in how we start to solve it with this bill. You have to realize that the need for measures like this could not be more urgent. ADL's most recent audit of anti-Semitic incidents tracked 2,717 incidents across the country, a 34% increase over the last year. The report also showed a startling 133% increase here in Georgia alone. We all know this. We've all heard the stories. We've spent this afternoon hearing these stories. The impact of rising anti-Semitism in the Jewish community cannot be overstated. You've heard all of this, and I'll be quick about this, but American Jews are living in an increasing fear of violent attacks, of being targeted by conspiracy theories, drawing on classic anti-Semitic tropes, of being marginalized by the statements that you've heard today. We support the specific use of the IHRA anti-Semitism definition, including the 11 contemporary examples that you've heard about today, as critically important to help identify, understand, and address anti-Semitic incidents so that we can work together to combat this form of hatred. Only by understanding what it is, defining and clarifying what it is, and I'm a lawyer, and I understand the importance of definition in the actions we take as lawyers. This gives you a definition that we've never had before in the state of Georgia. We have to be realistic to understand that we can't act unless we know what we're acting against, and that's what this definition is for. We appreciate the Georgia legislature showing their leadership uniquely among the states in the Southeast to add to those you've heard about already in the legislature to take this growing crisis seriously, and we look forward to supporting you in these efforts. Thank you for the work that you're doing, for your attention that you're giving to this extremely important issue. Thank you, Mr. Chairman.
Thank you. Any questions by members? All right, thank you, sir. Oh, hang on. Representative Leverett.
Yes, sir.
One question. I'm assuming your organization supports the bill as drafted. Would you support it with something like the IHRA definition, but not an incorporation of that definition?
Are you talking about the specific incorporation of the language in the bill? We support the drafters who intentionally decided not to include it, but I would tell you if it's to die on, I would rather include it so you have a definite definition in the document, in the body of the document, which I understand is a concern of the members today. It's not for me to say. I defer to the drafters, but I can understand your concern and your reliance on the definition.
One other question, Mr. Chairman. And so, I understand you say you would prefer that it remain as it is, but but you would accept it if it's recited the definition in the text of the statute.
It's not for me to accept, but I think that the members, if they were deciding between not approving this bill and approving it, that to have a static definition as it currently reads, incorporated into the document, does not hurt the bill. And I would defer. I'm not speaking on behalf of ADL, but as fellow counsel, I can understand your concern of incorporation. The language makes sense.
Okay, thank you.
Rabbi, we were given a handout from the Department of Education, U.S. Department of
Rabbi?
Education. I'm sorry. Okay, wrong speaker.
Wrong speaker.
I was looking at a note.
Thank you for the compliment.
I was looking at a note. So
Sorry.
ADL.
ADL
representative.
Yeah, ADL.
Yeah.
My mother would be proud.
All right.
Yes, sir.
We were given a handout from the U.S. Department of Education, and they put several other instances of religious or ethnic discrimination sort of on par with discrimination against Jewish people, but they don't define and they don't even articulate the problem of anti-Semitism. And do you think that might be the reason that these schools are having some confusion about acting against anti-Semitism?
I agree, sir. I think that the lack of clarity on the question of what is it that we are all dealing with is the problem. And the effort by the drafters to include that in our Georgia code is extremely important, and I think why you're hearing majority of support for this bill today.
I believe that's all the questions. Thank you, sir.
Thank you.
Sally Levin, I hope I'm pronouncing that right. Levine, yeah, okay. When I was on the bench, I used to be pretty good at that, but I'm not anymore.
It's one of the approved pronunciations, just not ours.
All right, you got 3 minutes.
I know, sir. And thank you for the opportunity to speak today. I'm Sally Levine. I'm going to speak in support of HB 30. I am the executive director of the Georgia Commission on the Holocaust, and for those of you who know us, we are a secular and nonpartisan organization. I'm just going to talk a little bit today about some historical context about why I think this is important. And one of the points that was made here today was that when you legislate something, when you put it into the law, it has to change people's behavior. And you can't change people's hearts quite as quickly as you can change behavior. In Nazi Germany, everything that happened was legal. It was made through laws, and they were passed. So it's important for us to understand that anti-Semitism can't be allowed to thrive when it grows without challenging it. And this law will do that. In Nazi Germany, the government implemented anti-Semitic laws and used propaganda incrementally, and these changes received very little opposition by ordinary Germans. Public apathy emboldened the Nazis to increase propaganda and restrictions against Jews. We know now that this apathy ultimately ended with violence and then mass murder. In the face of rising anti-Semitism here in our state, in our democratic society, we must not stay silent. We must not tolerate hate, racism, and anti-Semitism. It's time for each of us to speak up, to step up, and to support this bill. We can't get rid of the good because we're seeking the perfect. This is going to help us. This is also going to hold our state to a very high standard, and for that I'm proud. We can't stand against anti-Semitism without being able to understand what it is. Ambassador Deborah Lipstadt, who we mentioned as our special envoy to monitor and combat anti-Semitism, wrote, "Action starts with understanding." That's what this bill does. It's a foundation that's going to lead to action that will lead us to stand up against anti-Semitism. I hope that today you'll all support the bill. I stand and our organization stands against racism, anti-Semitism, exclusion, and hate. I hope you will all stand with us. Thank you.
Thank you. Any questions about the committee? Okay. All right. Thank you, ma'am.
Thank you.
Connie Sosnoff. Hope I got that right.
Been waiting a long time. Hi, I'm really glad to be here. My name is Connie Sosnoff. I am half Korean and half Jewish, and I've been a resident of Georgia for 32 years. I'm very concerned about the bill on First Amendment rights issues. Some of the supporters of this bill say it won't affect First Amendment rights, but I disagree, and I'm going to give you two examples. One is a potential example that might happen if this bill is passed, and one is something that happened to me. You all know it includes criticisms of Israel, and that's what makes it problematic. This is the potential problem with the bill. If I attend a rally in front of the Israeli consulate on Spring Street because I am opposing their human rights violations, and I get arrested for blocking the sidewalk, and I'm holding a sign that says Israel is an apartheid state, and I get arrested, I get convicted, then the DA can then enhance my punishment because I also, if he decides that calling Israel an apartheid state is anti-Semitic and shows anti-Semitism, then my punishment will be enhanced. And so you all heard that, the Israeli lobby groups and many American Jewish groups have called Amnesty International anti-Semitic because they reported that Israel was an apartheid state. They had a very long report. Human Rights Watch also made a very long report delineating all the human rights abuses that caused Israel to be called an apartheid state. Well, both organizations were then called anti-Semitic. In fact, the head of Human Rights Watch, Kenneth Roth, was offered a fellowship at Harvard University, but the dean withdrew that offer because of his criticism of Israel. And then there was this mass media about how Harvard University was being influenced by whoever, and so they reinstated the fellowship. And what Kenneth Roth said was that he got his job back because he was well known and well respected in the human rights community. But those of us who are not well known that would never happen. We would just be lost because we were charged with anti-Semitism. The second example is something, I'm skipping the second example. I'm going to just give you the third example. So in 2019, I was invited to Georgia Tech by a student group during Israel Apartheid Week to talk about Palestine. And we were warned that the talk would be interrupted by members of Hillel, which is a Jewish student organization on campus. To avoid this, the student group that invited me decided to only allow students in the room. It was a student event, only allow students in the room, and so they didn't allow a couple of employees of Hillel who were not students. What happened was Hillel charged the university with anti-Semitism because they said, can I finish? It's really interesting, come on.
I understand, but I'm running out of time.
I know.
So.
They said that they were not allowed in the room because they were Jewish, but they were not allowed in the room because they were not students. And we knew they were going to try to disrupt the talk. So anyway, 2 years later, a federal complaint was made against the university based on Trump's executive order that said, that directed the Department of Education to apply the IHRA definition. And in fact, the charges were finally dropped after they were sued by the Hillel employee, and the charges were finally dropped because Georgia State agreed. Georgia State. It was Georgia Tech agreed to consider the IHRA definition of anti-Semitism whenever they had something like this happen again. So to me, that means no student group is going to be able to have a Palestine event on a campus if this bill is passed, because people are going to charge anti-Semitism because they do it every time. And if you have criticism of Israel anywhere, that is going to be anti-Semitic. And I think that's my free speech rights as an American citizen, and I really don't want you all to give away my free speech rights to a foreign government. And thank you very much.
Any questions from the committee? Seeing none, thank you. Renee Evans.
Good afternoon.
Good afternoon.
My name is Renee Evans, and I'm the Southern Regional Representative for the World Jewish Congress. I am a faith leader both under President Trump and President Biden. I am also an advocate for AIC. I was asked to come here today to speak about involvement dealing with anti-Semitism in the school systems and the importance of the passage of HB 30. My advocacy started in 2017 when I met Beth, and I'm not going to go back into that, but it was classified as one of the worst anti-Semitic incidences occurring in the public school system in Georgia. Beth's incident and others occur because there is no definition of anti-Semitism. What they experience is why this definition is so important. Georgia's #1 in business. Congratulations. I support our governor and thank you so much. But we're also known in top of the world as having hate in our schools. It's not only seen in Georgia, it is seen worldwide. When I am at the Knesset, they asked me, or that is their Senate, they asked me, what is going on? We brought members of Knesset here back in 2015 because they wanted to invest in our state. We decided we want to be #1 or #2 right now in the high-tech field. So we decided to go ahead with this. Their only request was that their children and their people remain safe. We are #2 in the nation right now for high tech. This is money. This is serious money coming into our state. Georgia should not be a state that does not accept hate in our schools. We actually rank in the top states with continuous anti-Semitic instances reported in the press worldwide. So here's some reasons why we need this. For our students, we miss this teaching opportunity to talk to our students about anti-Semitism and hate, and the lessons we can learn with a concrete definition of anti-Semitism. It can then be applied to the recognition of all forms of hate and why it is wrong. How can you say or teach what anti-Semitism is when there's no definition of it? For the administration, anti-Semitism is not always clear-cut. Without a definition of anti-Semitism, the administration does not always recognize or understand what it is. It also places them in the middle of a he said, she said, parent versus parent situation. The definition enables teachers and administrators to easily classify if an incident is anti-Semitic or not. It also gives the administration a leg to stand on for determining what the punishment should be. What happens when there is no definition? These students feel helpless, hopeless, and become withdrawn and depressed. We've seen this happen not only in one county, but numerous counties. The parents either remove the students from the school and place them into another school for their own safety. They sue the school system because you do not provide a safe place for them to learn. Or, in best case, these children feel so hopeless, they go ahead and try to commit suicide and take their own lives because they have no other option. We have had numerous cases of this. I get numerous phone calls. And unfortunately, we have lost 2 children because of this, because we do not have a basic definition. You ask me, how can this help? I can't even tell you how many times little bits of anti-Semitism are coming in our schools. We have jihadist symbols in our schools, and our administration thinks, oh, because it says camp and something in Arabic, this is okay. They don't understand that it is a jihadist symbol. It says jihad, and they run around our schools because Kanye West, Bella Hadid, influences, the internet all says how cool it is to go against Jews. This is what we are allowing because we do not have a basic definition. We are not even giving the tools for our administrators to put a stop to this. This is what happened with Beth. I didn't want to start in this, but no one else stood up to help her. We should be ashamed when we can't determine a 3.5-foot Nazi symbol as a hate crime. One parent said, oh, it's a peace sign. This is not a peace sign, people. Okay? When something reads, kill a Jew, kill the Jews, gas the Jews, the police department should be able to understand that that is a form of anti-Semitism because the gas refers to the 6 million that went into the gas chambers. And yes, to an anti-Semite, that's not a problem because there is no definition, and because there's no definition to them, it's not anti-Semitism. There's nothing wrong. And this is the exact case. This is a real world case that happened in Fulton County, North Fulton County. That not only extended there, we had to go to Cambridge. Do you know what it's like to go to the Department of Education and have to turn to the Department of Justice and for them to come to our state and say, if y'all can't take care of this, we're going to? And I have to push it that far as a citizen. Think about what that will do to your taxes. Do you think people want to live in those places? North Fulton holds tens of thousands of Israelis. You heard it, tens of thousands. And why? Because we are a high-tech area. They buy homes, they buy cars, they come here to send their children to a safe place. You asked before, I worked in the administration, and you say, why are these people, they canceled this lecture. Well, they canceled the lecture because the person who was speaking was a known terrorist who committed a terroristic crime and blew up an airplane. That's what you want to have in our schools. This is what you're allowing because we don't define this ridiculous thing. And yes, whether it's a little symbol of a cartoon character in a middle school cultural event, and you're saying, what the heck is this thing? Most people wouldn't know what it is. Well, it's a symbol for the oppression of the Palestinians, and under it says, to the sea. To the sea? What that really means is you want the destruction of the state of Israel to reclaim that property from the mountains to the sea and murder innocent children, parents, civilians, Christians, because they are not part of this culture. This is what's in our school. This is the beginning of what is in our schools. You have the power today to say enough.
Ms. Evans, you're very passionate.
Oh, sorry.
And way over your time.
I apologize. But people are not let go from universities for no reason.
All right,
I'll
thank
just
you.
leave it at that.
All right,
Thank you.
You made a good point. All right, no questions. What's the will of the committee?
Mr. Speaker.
Yes, sir. Oh, I'm sorry, John, I need to give you time to come back. Hang on.
While Representative Carson's taking his seat, I would like to raise the issue. I maybe should have been quicker on this. The hate crimes law, I know many of my colleagues worked on that, has designated misdemeanors, which are assault and battery and other crimes against people and property, but blocking a sidewalk would not get into the hate crimes law. It's crimes against people and property, assault and battery, and the like.
Thank you, Mr. Chairman, members of the committee. I appreciate this spirited debate. I characterize it that way. I want to thank my legislative aide, who, as well as a couple of groups that provided some examples to address Chairman Leverett and Chairman Smith's concerns. This is the Tennessee legislation. This is their House Bill 2673 that includes the IRA definition by reference. I'm sorry, I didn't mean to throw it. Also, to the committee, and I'm sorry, I don't have copies for everybody. I hope we can pass this around or what have you. This is Arizona House Bill 2675. This includes the definition of anti-Semitism by reference as well. That's Arizona. And this is Iowa's House File. They call it House File, not House Bill, but House File 2220. And this was just recently passed, and this is also by reference. The other states that we mentioned are by resolution. I just want to, again, say thank you to the committee for hearing this. This does not impede free speech. And I think it's very important to say that. And I thought I made it clear at the beginning, but this does not impede free speech. I would ask the committee's indulgence, what the will of the committee. This is exactly the same bill, just clear as last year, House Bill 1274, to protect our friends in the Jewish community. And we did make it clear that this includes the examples that the IRA definition lays out. I would prefer, if I may, to pass it just like we did last year with that one change. If that's not the will of the committee and we need to do some homework, then I'm happy to do that. And I'm not I think people know me around here, I'm not afraid of a little bit of work. And I will say this, as a Baptist, I'm not afraid to fight for the Jewish people either. So if I need to do some clarification with some of the chairmen, some of the people in the minority or the majority on the committee, whatever I need to do, I'm happy to do that. But I also had a couple of items. The White House several years ago included, I think to the prior speaker's point, the definition as reference. It's also done the same way as the Department of State and Education, as well as it was done by reference in New Mexico by executive order.
All right. Representative Bruce?
You asked what the will of the committee was.
Yeah, I jumped ahead of, I wanted to give Representative or Chairman Carson an opportunity to speak.
Okay.
To respond and then have a discussion about what we want to do.
Okay, are we there yet? Are we?
I'm not sure.
Could I give?
Sure.
With your timer. I like the timer. Can we give 90 seconds to Mr. Goldfeder to wrap things up?
You don't have to. I don't have to time it. Go ahead.
I'm sorry, Mr. Chairman. I just
I
feel
don't know if this mic on.
I just need to set the record straight on a couple of very important things. First of all, not a single person here could point to a single provision in this bill that would affect free speech. As to the examples given, of course you can protest against Israel. You just can't then commit a hate crime because you don't like Jewish people. Amnesty wasn't called anti-Semitic because they called Israel an apartheid state. Amnesty, in their report, changed the definition of apartheid from involving race to involving citizens so as to include Israel. By the way, who cares? The bill doesn't talk about that. If Amnesty then commits a hate crime, maybe it would be an issue, but it's not. This is not personal to the CARE representative, but he misrepresented a bunch of things. The Biden Department of Education did not stop using IRA. They delayed issuing further regulations of Title VI and explicitly said they're going to continue using IRA as per the executive order. Also, the cases that he talked about, I'm sure these are national talking points, they're wrong. They're misrepresented. Those are
Tap your microphone. I'm not sure
Sorry.
it's coming through.
The cases he talked about are Title VI cases. They didn't involve speech. They involved conduct that was so severe or pervasive, it prevented Jewish students from partaking in educational activities. How do I know this? Because I filed some of them. I filed the Georgia Tech complaint. It had nothing to do with Palestinians. It was a young Democratic Socialist Club who didn't let a woman in because she was Jewish. How do I know? Because they told her, we're not letting you in because you're Jewish. We filed the complaint, and guess how Georgia Tech settled it? They realized they were wrong, and they adopted IRA going forward, and we've had a great relationship with them since then. It's actually an excellent example of how this is supposed to work. I didn't want to do this, but I think it's very important, and again, this is not personal to anybody here. CARE actually is a really important reason why we don't want to put the definition into the bill itself. CARE is not a neutral party here. Last year, in January of 2022, shortly before the terrorist targeted a synagogue in Colleyville, Texas, that you heard about, one of CARE's executive directors gave a public speech, and she called synagogues and other Jewish organizations enemies who are part of a massive conspiracy behind Islamophobia. She made them targets. Now, there was near universal condemnation of her comments from the entire Muslim community except CARE. CARE stood proudly behind her and defended them as, and I quote, merely expressing an opinion about Palestinian human rights. Boggles the mind. Boggles the mind. But if you put the definition in and you allow people to start red penning it to make sure that their anti-Semitism is okay, you will water it down, you will make it easier for anti-Semites to keep on doing these things. By the way, anti-Semites don't care if you personally target it, like Israel or don't like Israel. I won't make you all read my law review article, but I can assure you that at least a third of the time, if not more, the people who are targeted are anti-Zionists. They don't like Israel, but they're targeted because they're Jewish, because of Israel. And by the way, if you want the one surefire way to protect against a fake charge of anti-Semitism, it's have a definition, and then you can prove that it's not. And I'll just end by saying not only does our definition literally say criticism of Israel like any other country is not anti-Semitism, it also says that every one of these examples, including the ones about Israel, are only contextually, possibly anti-Semitism. The reason it's there is not because criticism of Israel is always anti-Semitic. It's not. It's because some people want to say that it's never anti-Semitic and it can never cross the line and you can do terrible things and then hide behind it and say you were just defending somebody else's rights. Thank you for your intelligence.
I should have put a timer on you.
I told you. I told you.
Okay. Representative Evans.
Just a quick question for Representative Carson. How long has the federal government, Department of Education, been using the IRA definition for anti-Semitism?
I believe it's about 4 years. Mark, do you have that number? 2019, so 4 years.
Okay, thank you.
All right.
I'm sorry. Did you say Department of? Did you say Department of Education?
I was asking for both.
4 years.
Well, the federal government, the Department of Education.
Okay.
So it's been quite a while. So I think Representative Carson, you might agree with me that us doing this now is not going to have a chilling effect on speech.
Completely agree.
Okay. Vice Chair.
Mr. Goldfeder, the law review article you mentioned, the title and the publication. Tell us about
Defining Anti-Semitism, Seton Hall Law Review in 2021. There's a second one out now called Codifying Anti-Semitism, which is in Penn State Law Review. It actually came out last Friday. It goes through everything we've talked about here, explains why it would be impossible to limit or chill free speech under the law under this bill.
Thank you.
Okay. All right. I want to bring Mr. Quadja back up for a response. And I hate to put a limit on you, but we're running out of time.
I'm going
so-
to be very short. I
Okay.
promise. But I'm going to preface with one thing, though. I understand that this can go in a back and forth, and there's an order to things, which is generally appreciated. I think this is going out of order, and there's a reason to that, because then people can go back and forth all day. And I expect this committee to read the materials we provided, debate on it, think about it, and then make a reasoned decision. So I'm not going to touch upon every single point, but I do think it's important. I have the article right in front of me from the Jewish Journal, which says the Education Department delays regulation codifying IHRA for a year. That is absolutely in its plans to, and they're delaying it for reasons. And that's not something I've misrepresented. I'm not going to touch upon everything else, but every single CARE chapter runs independently as a separate legal and tax entity. I do not speak for CARE Texas or any other CARE chapter. I'm here to speak for CARE Georgia. I think the comments were actually taken pretty poorly and were in poor taste, but it's okay because we're here to address something that's serious, which is Georgians who are facing anti-Semitism. And I stand with you in trying to address that regardless of if our means are different.
Okay, thank you. All right. Chairman Carson, anything else?
I wouldn't dare.
Oh, thank you. All right. Discussion by the committee. What do y'all want to do? Oh, sorry. Representative Bruce.
Okay, I think that the definition is necessary. I'm not sure that this bill that they're telling me that the definition is not in is the definition. I'm confused by that. If the definition is not in the bill and it's supposed to be about the definition, then what is the bill about? That's first thing that comes out. I would suggest that we just delay the vote. I think that there is still too many questions by the members. I know we have some questions, and I think we should take him up on his offer. He offered to work with us to be able to answer questions, and I think we should take him up on his offer.
All right. Do you wish to
I
make
put
a
that in the
motion?
form of a motion.
A motion to table?
Well, it's not really tabling, it's just that we don't vote today. Well, table. Okay. Move the table. Move the table until we
All
get
right.
further information.
I'm not sure, but do I hear a second on that? I don't know if it requires a second. Representative Kelly.
I want to be clear. I'm really sitting here struggling because I voted last year to support the reference in the legislation, and I'm still not 100% convinced that that's not the proper thing to do. Last year, I think it was good enough as a committee to move this bill forward with just the reference. It went to the House floor and only had 19 no votes. I think this is important what we're doing today. I hope it's something that when we get back in front of this committee that we can support unanimously. Today I have some concerns that not everyone has been convinced that the path we took last year is that correct path. Now, I don't think I've moved past that, but I think this is such an important topic that it deserves us taking a more, a continued measured approach like we always do in this committee, to have some more conversations with the bill sponsor, and then let's move forward. And at that point, that's why I'm going to second this motion, not because I enjoy delaying the progress of something that I think is so important, but because I want us to make sure we have a piece of legislation when it leaves this committee, we can vote for it unanimously. So that's why I'm going to motion to table.
All right. We have a motion and a second to table. Any other discussion on that? Representative Evans.
Very briefly, Mr. Chairman, my preference, for what it's worth, would be to pass this today. I think we gave it a lot of deliberation last year. I think we've given it a lot of deliberation today. This reference to the IRA definition, we're not the first people to do it. We're not the second. We're not the third. We're not the fourth. We're not the fifth. We're not even the sixth. There's precedent here. It's been done, sounds like, since as early as 2006, and I think it's the right thing to do. I think it's a need. I want other members to get comfortable, so if that's how we have to do it, we have to do it. But I would impose on all of us to think about why we are delaying, because we heard a lot in here about things that folks are concerned about that are not in this bill, and that happens to us a lot. We have to pass laws based on the words. These words say it's not going to you can't do anything that infringes on free speech. We don't change what you have to prove to do harassment. you can be anti-Semitic and not be in violation of this law. It's used, you say anti-Semitic things and you commit a crime, or you discriminate against someone, you fire someone, not you just have opinions. So I just want to commend all of us to think about our duties as legislators, which is to look at the words and not let rhetoric outside of this room or what people think is in the bill that's not in the bill stop us from doing our job to protect the people of Georgia.
Thank you, Representative Crawford. Representative Crawford? No? All right. Let me just say this before we do anything else. Just sitting here with my experience as a judge, the word working causes me problems. You have a date here to, be specific as to the definition that you're going to use. But when you put that word working in there, I could read this to say that that may change. Mm-hmm. That's movable. So, that's one problem I have with this. If you don't put the definition in it, that word working opens the door for a judge to interpret this, that you can do anything with it. So you can just look at whatever one you want. So, all right. Chairman Smith.
Thank you, Mr. Chairman. Very sympathetic to the bill. I wished I had went back and watched the footage from the last committee meeting we had on this bill. The issue in Fulton County is really problematic to me. Why is this conduct not being prosecuted? Other instances across the state. So in my mind, if I have a prosecutor that is not basically prosecuting this conduct because of anti-Semitic feelings that they harbor and may have manifested, I want to be able to see whether they would qualify to be impeached by this legislature for being anti-Semitic and applying the law. Okay, let's fast forward that. I don't know that any of us here have been a part of the impeachment process in the legislature. Not even Buddy over here, I don't think. Joke, Buddy. But I'm sitting here and I'm thinking about somebody brings articles of impeachment, and bear with me through this hypothetical. I'll try to be a little faster in my speech, but I'm sitting here, we're bringing articles of impeachment against this anti-Semitic prosecutor, but I don't have a definition of what anti-Semitism is, and specifically within statute, not just by reference. I'm good with the definition that they adopted on 26 May 2016. But as far as how this works, how are we really going to get to anti-Semitism, my preference is to see this within the statute itself, to be doggone clear, without a doubt, that this is the kind of conduct that we consider, or speech that we consider to be anti-Semitic. Speech that incites people to violence. I think that's what we're getting at, and I appreciate everyone that has commented on that. I know other members of the committee have been a little frustrated. We've had some concern, and I appreciate those of you that have addressed them, and I know everybody has to say their piece. I get that, but thank you for helping us address these. But for me, that's the only issue I have with the bill, is wanting to see statutorily the definition there clear as night and day.
All right, thank you. Who's 14? Representative Loach.
Mr. Chairman, as you know, I'm new to this committee, but I have this question. If what's holding us up today and a possible reason for delay in action is because we want to see this actual language in the bill, does this committee have the authority today to amend the bill to put that in there?
It does, but we have a motion to table on the table right now that we need to deal with.
If that fails, then a motion to put this definition in would be in order?
Yes, sir.
Thank you.
Representative Kelly.
To my friend and the chairman of the ethics committee, I think there's still some of us who, I think for some of those who my friend here is passionate about putting the definition into the statute, I think there's some of us who are equally as concerned about putting it in the statute versus just doing some form of reference. I know the chair is reference. He has a concern about the reference to working definition. I guess whether we follow through on this motion to table or whatever, I think is moving forward. Another option I think that is up for debate would possibly be just striking the word "working" in front of the definition, so that we maybe handle it that way. And so that would be an alternative that I would offer some of my friends to the actual codification of the definition. But that's if we're going to make too many amendments today, Mr. Chairman, I think I would rather take a pause so that we can have some time to deliberate and also consider how this fits in with some of the protections we've put on campus speech in the last couple of years.
Okay, thank you. All right, let's vote on the motion to table, because it really doesn't make any sense to keep going until we make sure what we're going to do. So all those in favor of the motion to table, say aye.
Aye.
All those opposed, like sign. No. Ayes have it. It's on the table. We'll take this back up later on.
Thank you.
We'll put a notice out. Thank you, all of y'all, for being here. I appreciate the speakers who came up to talk. Thank you.
I need 2 signatures from you.
Okay.